calendar. Let me just find the calendar on my desktop here.
And okay. All right, YouTube is going, and so is the recording to the cloud. We are good, Madam Chair, anytime.
Okay, good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Wednesday, December 16th, 2020. The time is 9:00 a.m. and we are meeting via Zoom remotely due to the current pandemic and the stay-at-home orders in the state of California. We have a full calendar today, and so we'll try to be as efficient as we can and get through each matter quickly. We have two matters that are rescheduled or off calendar. Our hearing board general meeting has been canceled because of how full our calendar is. And the matter of South Coast AQMD versus Mission Foods, case number 5400-4 for a modified order for abatement has been rescheduled to December 23rd. We have two matters on the calendar, and unfortunately the chair will have to leave whatever hearing we're in at 2:00 for a pre-hearing matter as well. And so hopefully we'll be able to get through the day with the two matters either before then, or I will come back and finish up after that. I'm going to take them in the order in which they are on the agenda, which means I'm going to take the matter of Redlands City Wastewater Treatment Plant, case number 3976-5 for a regular variance first. And I'm going to call for each of the parties, and then we'll get an assessment on how long we think it might take so that those who are waiting for Chiquita Canyon can know how long and about what time we think we'll take that matter up. So who is representing the petitioner Redlands City Wastewater Treatment Plant this morning? I'm sorry, can everyone hear me?
We can, Madam Chair. I think they're muted.
Okay, who is representing the petitioner? You can
Okay,
raise your hand.
Redlands, your phone is unmuted.
It is muted.
Ms. Pruzak, we have the MUED director and his department staff present. Also, I'm present. My name is Chris Boatman. I represent the solid waste enterprise specifically at the city of Redlands. I'm here mainly to offer my understanding is public comment with respect to a condition within the proposed conditions.
Is there anyone who is actually representing Redlands City Wastewater Treatment Plant for the request for the regular variance?
Yeah.
Can you hear us now?
Yes.
Yes.
Okay, thank you. Sorry, we had a little technical issue. My name is John Harris. Monday of last week, December 7th, I became the director of the Utilities and Engineering Department here in Redlands. I'm representing the city. Chris has already introduced himself. We also have our city attorney, Dan McHugh, on the call, as well as Marcos Padilla with Montrose Environmental. That's the city team.
Mr. Harris, can you again state your name for the record and spell it, and tell us again who you are, meaning your title, and before you do that, I just had a question. Is there any possibility that you and your team or your witnesses are able to access the Zoom call through video?
So we are seeing ourselves on the screen right now in video. We have an issue in this room trying to run the audio in the Zoom meeting. So we are using audio via telephone. Are you not seeing this on the screen?
We do not see you on the screen.
Madam Chair, they're under the name of Shannon Simmers City. It's a conference room with about 4 folks.
Upper left.
Oh, I'm so sorry. I'm totally missing the corner. You're in my corner. Sorry. Okay, I do see you. All right. Okay, Mr. Harris, can you state again and spell your name and just tell us your title just for the record.
Yeah, my name is John Harris. It's JOHNHARRIS. I am the Municipal Utilities and Engineering Department Director for the City of Redlands. I just started in this position Monday of last week, December 7th.
Okay, thank you very much. And who is representing the executive officer today in this matter?
Brian Tomasovic, Senior Deputy District Counsel for the Executive Officer.
Okay, thank you. I'm going to start with Mr. Harris. Do you have any estimate on time for your direct case and introducing and questioning each of your witnesses?
Are you asking how much time we feel we'll need today?
Yes, just so we can get it, I'm not going to hold you to it, but just so we can get an estimate for the next matter so they know about when we'll take up the next matter.
Understood. So I think Kevin Watson here, as well as Brian, have done a great job of doing a lot of the legwork ahead of the hearing. I don't anticipate it would take more than an hour. I've also not been through one of these AQMD hearings in the past, so I'm not sure what the process looks like, but I think we have a workable document.
Great, and I'll explain that a little bit in a moment. And Mr. Tomasovic, for your affirmative case, how much time do you anticipate?
We don't intend to call any witnesses, but we do have witnesses available. The exhibit of proposed conditions that we sent yesterday had been earlier shared with the facility, but if I imagine input we get in public comment may have some questions or concerns with our proposed conditions.
Okay, all right, thank you. So I'm going to estimate that this matter will take at least 2 hours. So I think we will not get to our second matter for the day, Chiquita Canyon, until at least 11 o'clock a.m. So that's for the parties and members of the public. Okay, so what I'm going to do first is I'm going to mark, we did receive, board members, the regular variance, the proposed regular variance conditions. And I'm going to mark that. These are from the district, Mr. Tomasovic?
Correct.
I'm going to mark it as Exhibit A as an apple, please. A as an apple, those proposed conditions. I'm going to also share with the public, if there's any member of the public who wishes to be heard today, I'm going to share my screen for a moment and tell you how you also can access all of the documents in both of today's hearings. Okay, the clerk of the board has made it very easy and created a link on the hearing board page. So if you want to access any of the case documents and exhibits for today's hearings, please go to the AQMD website, which is www.aqmd.gov. At the top, you'll see the About tab. Please choose Hearing Board. Once you've done that, when you're on the hearing board page, click the link that says Hearing Board Case Documents, and you'll be able to find all of the documents there. It's very clear and very easy to access. I'm going to stop my share now. And Mr. Harris and all those who are present for the petitioner and for the public, this is just going to run a lot like a judicial hearing. We're going to ask you to present your case in terms of testimony, any other evidence that you wish to present. We need to make 6 findings today. Mr. Tomasovic will have the opportunity to cross-examine, and so will the board. We'll be able to ask questions about all testimony and evidence that you present. Then we'll turn to Mr. Tomasovic, who has indicated that he has staff members available for questions, but he doesn't intend to call them unless we do have questions. If we do, you can ask questions, and so will the board members. And then we will deliberate today on the 6 findings we need to make. Are you familiar, Mr. Harris, with the 6 findings for a variance?
I am not.
Okay. I don't have that document readily available to share with you. Essentially, you need to demonstrate that you are in violation or will be in violation of any rule of the district. You need to present evidence to this board that it is beyond the reasonable control of petitioner to be in compliance with the rules that you are seeking a variance from today, which goes back in time. So we would need a timeline of what the issue is, when it occurred, when you could have corrected it, what you have done to correct it, those types of things that will be very relevant. What will be the impact if a variance is not granted? We need to know the excess emissions so that we can weigh the impact to both the petitioner, and since you are an essential public service, to the public of not granting a variance. We need to weigh that against the emissions and the impact. We need to understand if curtailment was an option instead of seeking a variance, and how you are reducing excess emissions. And that would be under the conditions of the variance, and you can introduce that, the proposed conditions, as well as how you plan to monitor. I know there's a lot of monitoring conditions. And those are the findings we'll need to make today. Okay, and we could just take it as we go. And if you don't cover everything, we'll attempt to ask the questions that we need in order to get the evidence we need for the 6 findings. Okay, before we begin today, I would like to swear in all witnesses. So all of those who wish to be heard today, give testimony, or who are members of the public who may give testimony, if you can please raise your right hand at this time to be sworn in. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God? Just indicate that you do. Thank you very much. And with that, Mr. Harris, if you would like to make a brief opening statement at this time, which is just a summary of the position of the petitioner, you can do that at this time.
Great. So thanks. I really appreciate the board's consideration of the variance request. Again, I think Kevin from the city here and Brian have done a great job of working out the details that produce the document that you have in front of you today. Again, I'll say that I just came to the city from Big Bear Lake a little over a week ago now, so I'm still getting up to speed, but I can tell you one of the reasons I landed here is because it's a great place to live outdoors. I know this staff and all of those folks here in this room and others are passionate about air quality and all environmental issues within the city. We intend to become compliant. We've already taken a lot of steps to do so. We may get into some of this later, but of the 16 or 17 conditions that are listed, I think we are already practicing, we're already compliant in at least half of those areas, and they've already laid a path forward to become compliant in all of the areas. Again, I hope you'll bear with me. I'm the new guy. I'm getting up to speed. The subject matter experts are here, and I'm not familiar with the process, but I'm hoping I can lean on them to some extent to answer some of the technical questions that I'm not as familiar with. We also have Chris Boatman, again, will likely make comments during the public comment period. I am responsible for the utility side of the house, which includes the wastewater plant. Chris is responsible for the landfill, and both of those facilities are addressed or mentioned in this document. But again, we're on a path to become compliant. We're hopeful to do so, to at least formalize that agreement today. And we just appreciate your consideration of the variance request.
Thank you, Mr. Harris. Mr. Tomasovic, your opening, please.
Good morning, Madam Chair and members of the hearing board. Exhibit A, our proposed variance conditions, represents a large investment of staff time and resources, perhaps as much as I've done on any other variance case. And I say that not to discourage the board, but rather to inspire your confidence that we did a lot of front work in thinking about the petition for a variance, also questioning certain gaps in time and in content and how we got here. But we are ultimately supportive of the granting of a variance, subject, of course, to the taking of evidence and adoption of our proposed conditions. Just to break it down, this facility is a wastewater treatment plant. It currently has 2 boilers that are not meeting applicable NOx limits, and those boilers need to be replaced with compliant boilers. Our understanding is that the facility intends to come in with permit applications to install 3 replacement boilers. One complexity of rule requirements that is not captured in the petition is that at the time of initial enforcement with the facility, at the time the petition was even prepared, the source of requirements for these boilers was Rule 1146.2, which is cited on the petition. But it's now our position that Rule 1179.1, which was adopted in October of 2020, brand new rule, provides the emission limit that pertains to those boilers, as well as the replacement boilers that will eventually go in. But the same limit of 30 parts per million NOx applies to the boilers under either rule. Ideally, the petition and the notice for the regular variance might have also cited to Rule 1179, but we don't think that should frustrate the issuance of the variance. Rule 1179.1 is very new in its implementation, but we can say that the intent of that rule was to copy over the Rule 1146 requirements, not to try to impose anything meaningfully different. Our proposed conditions will assure the facility will be on track to comply with the boiler requirements for either rule. Separately, we also have a need to control sulfur compounds at the facility in order to meet applicable sulfur limits that are found in Rule 431.1. And this is a ppmv limit, parts per million volume limit, that pertains to emissions for the same wastewater treatment plant boilers. The wastewater treatment plant also routes some of the digester gas that goes to those boilers to a flare that is shared with a neighboring landfill. And the neighboring landfill is also owned and operated by the city of Redlands. So even as there are some facility permits that indicate a separate facility ID for that neighboring landfill, we take the position that the wastewater treatment plant and the landfill constitute one facility for purposes of compliance with Rule 431.1, among other things. And so compliance with Rule 431.1 is needed for the totality of operations. And that said, we have no indication that the flare at the landfill is not meeting the applicable NOx ppmv limit or sulfur ppmv limits under Rule 431.1. What we have in our proposed conditions is we're trying to address this chief concern that the totality of operations are meeting applicable ppmv limits at the relevant combustion points, and that the monitoring will ultimately be accomplished consistent with rule requirements. And so our proposed conditions set a course for that. As I alluded to in our initial review of this petition for a variance, we did have some questions. We saw this unexplained, seemingly overlong delay in getting it filed, a seemingly overlong delay in submitting permit applications that we hope will come in soon. Details in the petition were a bit lacking in terms of setting out a schedule for compliance. We recognize that with a regular variance, particularly where the compliance may take more than a year, that's something you need, a schedule for compliance. So our proposed conditions may appear to be lengthy, but they were devised to try to help coax the facility into compliance on a reasonable, smooth path, considering all uncertainties. Ultimately, as I said, subject to hearing of testimony, adoption of our proposed conditions, we do think we can support granting of a variance, but allow me to put in a quick word on the case posture. If this facility had not come in with this petition, or if a variance can't be granted today, candidly, we would be looking at the option of doing an order for abatement. But this is not preferred, at least for this case. It may be contrary to achieving an economy of hearing board proceedings. And most importantly, we do understand the facility is going to agree and abide to the proposed condition 13 to submit these necessary permits applications in the next 30 days. And that is a really critical thing that we need them to do. And if a variance can give them the appropriate promptings to get on the road and keep on the road to ultimate compliance, we think that'll be in the best interests of implementing our rules and protecting the public. As stated, we don't plan to call any witness unless needed. We do have available staff witnesses from enforcement and from permitting and engineering if the board should have any particular questions for them. Thank you.
Thank you, Mr. Tomasovic. A couple of things. First of all, since our clerk staff worked so hard on getting all the documents up and so easy to access, I was able to pull up the notice. And you mentioned that 1179.1 was not mentioned in the petition. It is not in the notice, but it is my feeling that the notice is sufficient, given that both 1146.2, which was noticed, and 1179.1 both deal with NOx limits for the boilers. And all we need to do in our notice is to reasonably apprise the public as to the subject matter. So notice is sufficient regardless of whether 1179.1 was mentioned. So we can hear this matter today. As far as you mentioned, hoping to get it done within a year, I'm not sure I saw anywhere in the conditions. Did I miss it? Is there a time limit on the term that is being requested today? And I guess let me direct that to, oh, go ahead, Mr.
We have a
Thomas.
condition, Madam Chair, that says compliance with table 1 of, so this would be condition 16, compliance with limits in table 1 of 431.1 no later than 18 months after date of the variance.
Okay, and
Well,
that's
as a
431.1. There's also 1179.1.
same for the, this gets into details of the facility's construction schedule that maybe don't show up on the face of our proposed conditions.
We're going to need to have, so I'll just turn that over to Mr. Harris. This board will need to have a term that is being requested. And since it seems it will be longer than a year, we may need to pull some of these conditions out and make them increments of progress, because any variance that we grant for greater than a year must have increments of progress. And some of them can be. I know that there's the timing for submitting applications for permits and also time frames for once those permits are granted. So those can be pulled out on a break, and we're going to need to do that. Okay, thank you very much. Mr. Harris, Mr. Tomasovic said in his opening that this case is better handled as a variance. However, we do need to make the 6 findings. And I think your witnesses will need to explain the background and facts for us, but also explain why it is that we see notices of violation from a year or two ago, and it took this long to get here. So we'll need some explanation on that. And with that, as you introduce your witnesses, if you can just ask each one to state their name, spell their name for the record, tell us the title, their title for the record, and also let us know that they took the oath today. And you can present your first witness.
Okay, Kevin, you want to go ahead? Okay. My name is Kevin Watson. I'm the Utilities Operations Manager. My name is spelled Kevin, K-E-V-I-N, Watson, W-A-T-S-O-N.
My name is Shannon Simmers. I'm the Regulatory Compliance
I'm sorry,
Officer
can we take,
for the City of Redlands.
let me interrupt you. Mr. Harris, if we could take one at a time. What we'd like to do is take in order your witnesses, and then we will, that way we can take their testimony, question them, and then we can move on to the next witness. And if you could just decide who's going to go first and introduce that person first.
Yeah, I think that would be you, Kevin. Yeah, I think that would be me, Kevin Watson.
Thank you. And what is your title, Mr. Watson?
Utilities Operations Manager.
Okay, and you took the oath today?
Yes, I did.
Okay, thank you. Mr. Watson, you may proceed with any testimony you wish to give.
Hey, I began working for the city. My anniversary date was December 10th for a 2-year anniversary. So I've been here for just over 2 years. Been working, I'm over the wastewater treatment plant, the collection system, the water production and distribution, and fully aware of the NOVs and how it came about. The treatment plant and boilers were built in 1962, and at a time until 2003, we had a cogeneration that was subsequently taken offline. It is my understanding that we were meeting standards during that time, and in all regards, and that as the conditions changed and the boilers aged, as well as regulations changed, that there was some confusion, and we did receive an inspection, and subsequently in 2018 and 2019 issued a NOV. We immediately took steps to bring in consultants to work with us and consult with us and advise us. And we hired a design engineer who, not just the digester, but the entire wastewater treatment plant, performed an assessment and a design for us. When the 2019 NOV came into being, we took steps to expedite the digesters and boilers and gas conditioner design and procurement. That is not a quick process, but a lengthy process, because there's many variables that have to be looked at and considered. And so they have been working on that for us. Design has been completed. A construction contractor has been awarded the job, and we will be submitting the permit for construction within the next 15 to 30 days or sooner. And our goal is to order the equipment, and keep in mind that due to COVID-19, factory construction could be delayed, but the factories have indicated that they can meet delivery of the items by May. So of the gas conditioner and the boilers, we intend to submit the permit for application this next week, providing all goes well, and hopefully we intend to expedite that, pay for the expedited fee. Hopefully we will get the permit to construct prior to the delivery of the equipment that will be delivered, and begin construction soon after the delivery in May. We expect that the gas conditioner will come online in July, and followed by the boilers and heat exchanger. The construction process is a lengthy process, and it is best done in the summer months so that our digesters that relies on mesophilic bacteria are optimal, and that the closing or shutting down the boilers for a period of 60 days will not do do harm to the process, the treatment process. And we will only be taking one digester off a line at a time. So by having the gas conditioner online, feeding the existing boilers to keep us online, the gas conditioner will remove the sulfur compounds, and even the existing boilers will operate better than they have been. Given that, because of the demolition and the new piping arrangements, it's necessary to follow in this sequence. Followed after the conditioners constructed will be the construction of the boilers and heat exchangers. Again, one digester and one boiler at a time to go through a logical process to keep our treatment plant operating optimal. So our schedule for completion of the gas conditioner is right now to be in July, followed by the boilers in September and October. So we would hope to be in full compliance before the end of 2021. And we do appreciate the AQMD providing some leeway suggested in the conditions of 18 months with the knowledge and understanding that delays could occur that are out of our controls, such as if the pandemic worsens and factories close, if we can't get the equipment to construct, that is our main concern. And we intend to follow the conditions set out by the AQMD. We have gone through that with our team and do not see issues with meeting any of these and intend to fully comply. And I guess I'm welcome to receive any questions you may have, or if you need any more in-depth explanation of any of my testimony.
Thank you very much, Mr. Watson. That was some very helpful testimony to the point. Mr. Tomasovic, do you have questions for Mr. Watson?
Yes, thank you. Hey, Mr. Watson, good morning.
Good morning.
In terms of the time it took you all to file a petition, can you speak to whether COVID impacts may have contributed to that? Or generally what all the impacts?
Yeah, the filing of the petition was prior to COVID when we initially filed it. Right?
The petition for
we started it.
was filed on November 3rd, 2020. Is that your question, Mr. Tomasovic?
My question, yeah, the petition was filed in November of this year. And so my question is, I understand you've been working on the petition a long time. And if you could speak to whether it was COVID or preferentially waiting for design and procurement things to work out, what caused the apparent months delay in coming in with the petition for a variance?
I would say it's a combination of all of those things. We have been working on the design for well before this petition, trying to determine what solution was, and the COVID did play some part in it for staffing and getting the information from all of our experts and technicians. So the main thing was the assessment and design. So we would have a solution once we set before the hearing board.
Thanks. Do you have a copy of the petition in front of you?
Yes, I do.
Okay. At the end of the petition, you've attached 2 petitions to operate, 2 permits to operate, I should say. The first one is permit number F78942. Do you see that in front of you?
Yes.
Is this a permit for one of the non-compliant boilers?
Yes, both of the boilers are non-compliant at this time.
Okay, and then 2 pages later, there's permit number F78943, and that's for the other boiler?
Yes.
And in these permits, there's condition number 4, correct?
Correct.
Or sorry, condition number 5, which says demonstrate usage of less than 9,000 therms of natural gas, or else comply with rule limits. So is the issue with these boilers that the usage went above 9,000 therms, and therefore they had to abide by applicable rule limits?
Yes, during the winter months, when we did use more than that, 9,000 therms, we needed to burn natural gas to keep the temperatures at 98 degrees in our digesters. This year and even going forward, we have instructed and trained our operations staff to make every effort to always run the boilers on the digester gas, the methane produced from the digesters, and only run natural gas as a last resort. So far this year, we have been able to run on the methane and not the natural gas. So it's our intent to continue in that practice.
Okay. Moving forward in your petition, there's a notice of violation attached, P69207. Do you see that?
I don't have that in front of me, but I am aware of it.
Okay. The first violation that's described on the notice of violation has a description that says burning sewage digester gas containing sulfur compounds in excess of 40 ppmv in equipment requiring a permit to operate. So my question for you, sir, is do you agree that the boilers at the facility were burning sewage digester gas in excess of 40 ppmv, according to what you have for available data?
Yes, I do.
And the 40 ppmv requirement comes from Rule 431.1 C2. Do you agree with that? The table 1
Yes.
of Rule 41. Okay. So for someone who maybe can't picture how your facility works or what your design and procurement goals are, you might think new boilers especially at this size, are an off-the-shelf type of equipment. And why couldn't these non-compliant boilers just be taken out and new boilers that are on the good list for meeting current limits just go in, even not in later in the summer or fall as you set out, but why not in the next few months? Could you speak to that and why you've said the plan is for the sulfur gas system to go first and then do the boilers? Could you speak to that?
Yes, I can. Our consultants and design engineers, when they studied this and our our digester gas, the concentration of the sulfur compounds, total sulfur and H2S, that a gas conditioning was required for us to meet not only the current standards, but the future standards. And so they have been working diligently in that design with our staff, and the procurement process of going through the design, that has to be submitted, several meetings with the design consultant and staff in the process going forward. We did look at the consideration of replacing the boilers. That without a gas conditioner, that wasn't feasible. So we had to look at the best alternative and what was best for the environment as well as the city going forward. And that solution, as it was posed to us, was the replacing the 2 boilers and heat exchangers with 3 boilers, 3 heat exchangers, and a gas conditioner. And I'd like to point out, not only are we putting 1 gas conditioner in, but we're putting in 2, so that when one is down for maintenance, we switch to the alternate gas conditioner. We also have designed an online continuous analyzer for the gas coming off the gas conditioner to reduce and remove the sulfur compounds so that the boiler will be burning clean. As I stated earlier, the existing boilers, it will benefit from that gas conditioning system. We will bring the gas conditioner, that's our intent, online first. That will make the existing boilers burn cleaner, and we will go follow in a progressive manner on replacing those in an expeditious manner on getting all 3 boilers replaced. The question was posed to our staff, and we looked at, well, what if we just first put in the boiler prior to the gas conditioner? However, that would we would be burning dirtier gas in our boilers and do harm to the new boilers, which might cause them to foul and make us exceed the emissions. We don't want to do that. It's our intention to put out the emissions at the cleanest possible as soon as possible. And we feel from our consultants and our staff that the manner we've laid out in our design and procurement will be the way to meet all those goals expeditiously.
Brian, you're muted. We can't hear you.
Thanks, Mr. Watson. Could you explain if there are other regulators that impact facility planning, including for this?
Yes, there are other regulators. The Water Board, for one, this is a wastewater treatment plant, and what is done in one part of a wastewater plant affects all the other areas. So we have a biological membrane reactors that treats the wastewater to a Title 22 recycled water standard that can be used for irrigation and recharge of the basin, which is a precious commodity here in Southern California. So it's very important that we have to follow all regulatory. So when we make any change to the digester, it's not only AQMD that we have to confer with, but also the Water Board. and we have the discharge limits as well for the beneficial use of the biosolids. That is also regulated. And if we fail to properly operate the digesters and we are not able to meet the standards required for beneficial reuse, then we can't dispose of the solids in this manner, and we'd have to find alternative methods. And through our studies, that could be in the millions of dollars added every month if we have to, if we would to off the boilers and not be able to use them to properly treat the solids.
You referenced the potential for delays that are out of your control. Understanding that you'd be submitting for expedited permit processing, have you heard, or has your consultant advised you that there may be delays on the South Coast side of things in terms of getting those permits to you, and that you need to wait for those permits in order to construct?
Yes, that has been brought to our attention, and we intend to follow the rules and regulations as to regards to the permit application and receiving that. Hopefully the board or AQMD will be able to expedite it. We do intend to pay for the expeditious. If it takes 4 months, that would fall right in line with our scheduling and would not pose a delay. However, if a delay is posed through that process, we will take necessary steps to abide by them.
Thank you. I don't have any further questions.
Thank you. Board members, anyone wish to begin? Mr. Balagopalan and then Ms. Verdugo-Peralta.
Yes, good morning, Mr. Watson. You're familiar with the proposed variance conditions?
Yes.
Okay, and so I have some questions on those. But before I get to that, I wanted to get into a little clearer understanding of when you when you got into in violation of a permit. So let me start with the Rule 431.1 of the sulfur content. When did you were previously, I saw from the petition, you believed you were exempt because you were less than 5 pounds per day of sulfur emissions?
That's correct.
And at which point, and were you monitoring daily to ensure that you're below 5 pounds?
Yeah, I'd like to let my environmental regulator answer that. She's more familiar with our sampling procedures, if that's okay. Shannon Simmers.
We'll wait, and so if you can't answer a question, just let us know like you just did, and we will hold that question until we have the appropriate witness. Thank you.
Okay.
Mr. Watson, then when did you get notified that you were in violation of that rule?
I believe it was in November of 2019.
And that's when the inspector gave you the notice of violation, or when during an inspection?
Yes, that's correct. And at that time, we started expediting our design through our design consultant to put the digesters and boilers on a priority schedule, and started moving that forward at that time. And we took it to our city council to approve additional funds to achieve that goal.
So, what were you doing at the treatment plant to reduce sulfur emission in a normal operation?
We would tune the boilers.
No,
That are
to reduce sulfur overall.
Okay, go
in
ahead.
I'm sorry, I'm not talking about the boiler, but the generation of sulfur from the treatment process. Let me rephrase it this way. Do you have ferric chloride injection or iron sponge to reduce sulfur emissions?
We don't.
You don't. Okay.
That's what we intend to install. So
Okay, and that goes. So that is the proposed gas conditioner. That's what you're proposing.
yes,
Okay. So, and then you will. And you also mentioned that you will have an online analyzer to measure the sulfur content. Is that?
that's correct. That will be leaving the gas conditioners prior to going to the boilers.
So that'll be done in conjunction with the installation of the gas conditioner.
Yes, and I'll be continuous monitoring.
Okay. Then you did see the condition it proposed that you do basically weekly monitoring of the digested gas using calorimetric tubes. And this condition number
Yes, and we
7.
agree. Yes. Yeah, we've read that and discussed it with staff and are taking steps to meet that condition.
Okay. Yeah, I just wanted to point out, I think there's probably a typo in that. If you look at condition number 7A, do you have that in front of you, Mr. Watson?
Yes, I do.
It says it's the second sentence says before January 5th, 2020. Should it be 2021?
It should be.
Okay. So I think that'll
2022.
that'll reflect in both condition number 7 and number 8 then.
Yes.
Okay. And B says analysis at least each 7 days. And I assume that's at least every 7 days. That's the intent.
That's correct. That's what we will be doing.
Okay. And you're familiar with, or somebody is familiar with the test method cited there, method 307-91?
Yeah, we have staff. Shannon Simmons is very familiar with these analysis.
Okay, I've had some questions on that. I'll wait till I ask her. Now, let me move to the boilers. The 2 boilers you had, they were fired on digested gas. It's supplemented by natural gas. And you said in your testimony that during the winter months, you needed to add use more natural gas. So you exceeded your 9,000 therms. Is that correct?
That's correct.
When did that occur? Or when did you know that has been occurring? How long back?
Okay, that was a regular practice to switch over to natural gas. And it's not a blending of the two. It's either one or the other.
Okay.
So when our temperatures in the digested sludge dropped below 98 degrees and we couldn't maintain it with the digester gas, the methane, then at that time operations would transfer over to the natural gas. We had a colder winter that required us to do that, and we did exceed the amount and the duration that we were using natural gas. Now we are okay.
I'm sorry. I'm sorry to interrupt. Go ahead. Finish it. I'm sorry.
Now we've taken additional steps to train our operations staff that once the temperature reaches 98, if we do need to switch to natural gas, as soon as it gets back up to 98, we switch at that time back to the digester gas. And we have been able to, since meeting with our inspector and going through the process with the operators, we are able to to meet this this goal.
So my question is, when, I know you've been there only 2 years, how far back has this been occurring, and how far, at your knowledge, when the 9,000 therms was exceeded?
Since 2018 and 2019, the winter months.
All right.
I'm sorry, I do hear someone speaking in the background. If you don't know, you could just say you don't know, and then we can take the next
Okay.
one.
Okay. Can I bring your attention to the condition exhibit A? And there is a condition number 9 about asbestos. Was that just,
Yes.
are you going to be doing some demolition and so forth? That's why the condition's there?
Yes, that's correct.
Okay. Let me then bring to, let's look at condition number 10. I'm trying to, because it says a petitioner shall expedite to the maximum extent possible the installation, startup, and testing of Rule 1146.2 certified boilers complying with Rule 1179.1. But do you know if those boilers, the new boilers that you're getting, 1146.2 certified, or?
Yes, they are. We selected from the list provided by AQMD
Okay.
for our design engineers.
And they'll be, and then they comply with the new limit, I mean, the same limits essentially that is in Rule 1179.1.
That is correct.
And would you be doing the same switching back and forth? You're not going to be doing dual fuel blending? It'd be one or the other?
It is my understanding that we will not need to switch back and forth. We will be able to, with this cleaner methane gas, we should be able to maintain the temperature with the boilers to maintain the temperature in all 3 digesters, and that is one of the reasons we have chosen to go with 3 boilers for process control versus the existing 2 boilers, which one of those boilers works on 2 digesters. That in itself posed an operational challenge. This is going to improve the process and maintaining the temperature in the digesters.
So they'll be fired almost exclusively on digested gas?
Can I just interrupt for a moment? I just want to make
That
sure.
is correct.
We'll just make an announcement that if a board member closes off their video, we just want to make sure that they are still listening to the proceedings. So I'll just make that announcement now. And I see that the answer is yes. So if you don't see a board member, they are still listening. Thank you. I'm sorry, Mr. Gallagher.
Okay, no,
You go ahead.
Okay, no, that's all the questions I had. Thank you.
Okay, then I'll turn to Ms. Verdugo.
Okay, thank you.
For your questions.
Thank you, Madam Chair. I'm looking at the notice of violation, Mr. I'm sorry, was it Mr. Harris?
No, Mr. Watson.
I'm sorry, Mr. Watson. Okay, and as I'm looking at this notice of violation, especially on number 2, number 3, and number 4, that's not about equipment. That's about personnel not doing something, and that there's no oversight for an individual who's supposed to have responsibility of either maintaining the records or preparing and submitting the annual reports of the monthly fuel consumption and the total sulfur content at the fuel. How can you explain this to us? What was going on that there was no record keeping on this?
I would like to, for you to save that question for Shannon Simmers.
Okay. Thank you. I'll ask that again.
Did you have any other questions, Ms.
No,
Green?
that was my main question.
I have that same question, and we'll get to that witness and also how that's going to be rectified moving forward.
Okay.
I have a few questions, and again, let me know if you can't answer that. You said
Sure.
that you estimate the project, hopefully, if everything went well, would take a year, and that 18 months is giving you the cushion that you need. So are you looking for today the variance to go through mid-June, essentially?
No, we still would like the variance to go through the 18 months.
I'm
so
sorry.
we don't have to.
I apologize. I meant mid-June 2022.
Oh, that is correct. And we want to do everything in our power to far exceed that
Okay.
date.
Understood. I just want to make sure we can put a date on what the request is.
Okay.
Okay. I'm just going to, these are probably in no particular order. I'm just going through my notes as you have been speaking. So you mentioned that you, since the 2018-2019 timeframe with your NOVs, you have since that time expedited, you were working to expedite boiler design, procurement, etc. Did you work at all with the district during this time?
Yes, we have been.
Okay, thank you.
And they provided us to certify boilers.
Thank you. I want to turn to because I had a question and it might be answered with what's missing. I'm looking at the petition. Do you have the petition in front of you?
Yes.
The second page, number 7. On my end, it's cut off. The last sentence it says is failure to maintain the appropriate digester operating temperature will. Do you have something else on your copy?
It says will result in an upset, which could then lead to a permit violation and or sludge treated to a degree that it doesn't meet beneficial reuse requirements.
Okay. So, and that was the question. The question is what would happen if you were unable to use these boilers because they're out of compliance? One would be resulting in an upset condition. The other, if you can just elaborate, I know you mentioned it somewhat, but if you were producing this sludge, and you can't stop producing the sludge, I assume,
right.
But you couldn't treat it properly, what would you need to do with it and what are the consequences of that?
We would be forced to find an alternative process, maybe hauling it to another facility that would accept it and treat it. That would be very difficult due to the volume of sludge and 6 million gallons per day of wastewater.
Thank you. And you mentioned in the petition that would also cost, and I think you mentioned today as well, that hauling would cost millions of dollars. Is that correct?
Yes, and that would be per month, millions.
Okay. I see 1.7 million essentially per month. Is that correct? Okay.
Yes.
All right. I'm holding that question. Let's see. Do you know the answer to this? I can also ask Mr. Tomasovic this question, but Mr. Tomasovic mentioned in his opening, and of course it's in the conditions, that new Rule 1179 is the newer NOx limits that need to be met. But do you also now still require a variance from 1146.2? Or does 1179.1 cover it? Yes.
Yes, I believe that fact will be, that will be a true statement.
And Mr. Tomasova, could you just let us know if you agree with that?
I think our enforcement position, Madam Chair, is that Rule 1179 supplants the requirements that did apply under Rule 1146.2.
So everything was essentially shifted over for these boilers to 1170.
Shifted over. So our enforcement position would be that they're an ongoing daily violation, not of Rule 1146.2 at this point, but 1179.1. However, the way that that might be explained is probably through legal briefing and legal interpretation more so than staff factual testimony on how it should work.
So it doesn't hurt if we include both, if we grant a variance today.
I agree with that, Madam Chair. It doesn't hurt.
Okay, thank you. I think those are all my questions.
Can I ask I'm sorry.
Yeah, did you have a
Can I ask
follow-up
Mr.
on
Brian Tomasova a clarified question on that?
Yes.
On Rule 1179.1. It does say 1179.1 that the date of adoption was the compliance date of the rule, but it also says in E2 that a unit not previously required to conduct an initial source test shall conduct a source test within 12 months from October 2nd, 2020. So it implies, I don't know if that's, that they have a year until 2021 to do the source test. If they don't do it by then, the existing boiler may be out of compliance. Is that your understanding too, or?
We don't interpret that to be of benefit to the facility here particularly. It may apply to other facilities, but I think one reading of 1179.1 is that there is a expectation of initial source testing. So in order to kind of reconcile and try to implement 1179.1, we do have, I think it's condition 15, that these new 3 boilers will do initial source tests. And that would be a distinction from the way 1146.2 operates, where they have that certified list might get you out of having to do some particular source tests. In this case, not only are they choosing certified boilers, but they also will be doing a source test. And I believe the plan on the permitting and engineering side is to also write that in as a condition for conducting the source tests. Whether they give them 18 months or lesser time, I would think it would gear more towards the lesser time frame of things.
But those are for the new boilers, so that's appropriate. But what about the existing boilers until the new boilers?
Well, I can proffer from an enforcement witness. If I were to call an enforcement witness, they would testify that the 9,000 therms limit was exceeded. The grace period for showing compliance with the limits, once that's exceeded, is already passed for both of those boilers. So that's why our enforcement position wouldn't be that they get a free pass and they get additional time for these particular boilers, but instead that there's a continuing violation from what the requirements that did apply at the time the NOV was issued under the prior rule continues up to present with the same applicable NOx limits. So that's our approach.
Okay. All right. Thank you for clarifying that.
Madam Chair, I have one more question.
Yes, Ms. Paducah-Peralta.
Thank you, Madam Chair. Looking at the proposed regular variance conditions on number 16, when we're talking about demonstrating compliance, what are you utilizing, or are you considering utilizing something like a Gantt chart, which is a tool for project management, a compliance schedule that you need to, I feel that you need to submit to the AQMD? Are you considering something like that?
Yes, we are. We will have a Gantt chart, and we can submit that to AQMD. and do all the necessary testing to demonstrate the compliance of the new boilers and gas conditioner once they come online.
Yeah, I would really like to include that in writing in number 16. Madam
And
Chair.
is that, it sounds like there's an agreement and we could add that as a condition, as long as there's an agreement and we can have a reasonable time frame by which that would be submitted.
And
Yes, we can provide that.
Okay.
ongoing and updated whenever necessary.
Yes.
Thank you.
Thank you. And that's helpful for a longer variance like this. Should we grant it? Dr. Bernstein, you have questions?
Madam Chair, I just want a point of clarification on the proposed regular variance conditions. Condition 6 and condition 9, should that be 2021 and not 20?
Very good catch. Let's make sure we get that throughout the conditions.
Right.
Correct. Those are all my fault. Thank you.
Okay, no fault.
I think we're gonna have to do that throughout. I think it's probably more. I see a lot of 2020. So we will do a universal edit to all dates for 2020 and 2021 and perhaps 2022. Well, I don't think there's any in here for 2022, but we'll make sure.
Madam
I
Chair,
think you have to be a
aren't
little careful because it has December 2020, so you have to be.
Yeah, some's correct.
Yeah.
Some are correct. I see a January
It
though.
looks like the January dates are, some of them were not correct.
I saw a January date in number 8, for example. So we'll have to,
Right.
we'll have
Gotta
to
go
be
through it.
careful with that. That's a good catch. Thank you.
Let's see how
Any
that's
other-
another pretty.
Any other questions for the
Mr.
witness?
Watson.
Oh, Mr. Watson, thank you.
Yes.
Okay.
Mr. Ali, I do have follow-up, but I don't know if Mr. Ali has a question.
Has.
Oh, okay. Just as follow-up, and I think Mr. Watson, you may have answered it, I might have missed it. The new boilers, the 3 boilers, they will be fired exclusively for digester gas?
That is my understanding. We will have a backup just in case, but our intention is to run them exclusively on the digester gas. And we don't foresee any reason why we would have to run the natural gas.
Yeah, when you investigated the new boilers to replace the existing ones, and I know you're looking at the list of 1146.2 compliant boilers, but I think they were probably all tested on natural gas. Do you have any guarantee from the manufacturer, or have you been that they will also comply with the digester gas, the 30 ppm, without any issues?
I will have to follow up and check on that, but there are guarantees in place from our engineers and construction company. But the answer to that, I'd almost guarantee that will be a correct statement.
And our consultant might be able to answer that.
Okay, thank you.
Our consultant may be able to answer that as well, who is also on this call.
Okay, maybe we'll defer the question to him. Thank you.
Okay.
Okay. Any other questions for Mr. Watson before we turn it over to the next witness? Okay. Thank you very much, Mr. Watson, for your testimony. Mr. Harris, I believe, given what we need for the 6 findings, we had 2 more major issues to cover. The one was the question that was asked by Ms. Verdugo-Peralta regarding past compliance issues and moving forward, how those are being addressed, as well as excess emissions. So with that, who would you like to present next?
I think Shannon would be the best person to speak to those issues, and I'll let her introduce herself.
Hi, I'm Shannon Simmers with the City of Redlands, the Regulatory Compliance Officer, and I did swear in this morning.
And can you just spell your name for the record as well?
Shannon. Last name is Simmers.
Thank you, Ms. Simmers. You may proceed.
I just want to thank you guys for the opportunity for this hearing today. I also want to give thanks to Brandon Idlian for bringing our situation to light and working with us over these past several months to try to help us gain a better understanding of our situation. And our ultimate goal, like our director had mentioned, is to be in compliant and protect the environment. I myself have been with the city for a little over 3 years, so kind of new on the scene compared to the length of the boilers being permitted. I came into this position and there was not a person in the position before I took over. And over the past several months or couple of years, have been slowly but surely going through all of our compliance situations and doing assessments, gap analysis, and trying to make sure that we are complying or build a path to compliance where we might find some weaknesses. One of the things that was a part of that was our permits, and to address some of the questions or the information I was hearing for Kevin Watson, we did have that impression that we were under an exception. And in reading Rule 431.1, it states that if you are a part of the exception, there is no reporting or sampling requirements. But we did do our record keeping as required, which included daily recording of gas production, gas consumption, and gas sent to the flare. We also were doing our boiler tuning. So I'm not sure how much more you guys want to hear about that. I'll leave it to you.
Thank you, Ms. Simmers. Then I will turn it to Mr. Tomasovic for questions.
Ms. Simmons, are you have you reviewed proposed condition number 13?
Yes, sir.
And by your understanding of that condition, do you know under 13C which option the facility is likely to pursue?
Continuous emissions monitoring.
Okay. And are you aware that most facilities of your type typically go for alternative monitoring plans applications?
No, I'm not aware.
Okay.
I'm not aware that most facilities do that. No, I'm not.
Okay. Would you agree that in conditions 7 and 8, if those conditions are met for gathering daily samples and weekly testing, that you would have a baseline of data with the quality and quantity to potentially go for an alternative monitoring plan application?
We certainly would have enough data to explore that possibility on the quality of our gas.
Okay.
As it pertains to what our boilers are treating and burning, consuming, that would not be applicable once we change the system. But yes, it would give us an understanding on what our quality of gas
Okay.
would be.
And I assume the facility does have a consultants hired to assist with the permit applications under condition 13?
We have a consultant who's on the meeting today who's been helping us throughout our process, and we will be reaching out to him for assistance if as needed for the permit to construct.
Okay. And you and your consultant, as needed, will also be conferring with district staff on the applications and any amendments that may be needed for those?
Yes, sir.
Very good. Thank you. No further questions.
Thank you. Ms. Verdugo Peralta, you have a question.
Thank you, Madam Chair. Ms. Simmers, why did you think that the city of Redlands wastewater was part of an exception? What led you to believe that?
In reviewing, first and foremost, it would be past practices for compliance for AQMD. So prior to my coming to the facility, we have no record of ever monitoring for H2S. We have always taken our daily records and kept those records. We have never submitted any other annual reports. And in reading our permit, which is very old, there is indication somewhere, and I don't have that in front of me, that at one point we were given an exception, that there was some H2S testing. I have some notes here that I provided to Brandon on, let's see, so I just have to refer to my notes, it's been a while. May 31st, 2019, I provided a letter to Brandon Idalian, and in that letter, response to item 1, provide records of total sulfur compound emissions calculated at H2S pursuant to Rule 431.1. And in my response, it indicates that monitoring was performed by the city in January 1, 1989 to February 1984, in which the H2S average concentration was 990 ppm, which qualifies for the less than 5 pounds a day exemption listed in Rule 431.1 G8. As such, the facility was not subject to the monitoring requirements in Rule 431.1, and calculations to confirm compliance with the emission standards were performed monthly using the 990 ppm average concentration. Furthermore, I stated that the city was unable to locate the original sample results for the H2S concentration that were performed in that time frame or any thereafter. So I had requested that the H2S concentration described in the documentation indicated in my statement be acceptable alternative to the actual laboratory analysis results. It was believed, I indicated that I believe that such records would have been confirmed during the permitting process by AQMD staff. Therefore, at some point in time, this was done. And that's what led us to believe we were under an exemption.
Did you receive a response to that letter?
I received a response, I cannot remember if it was in writing or by phone, where we were told we were taken out of the exception because we did not have any monitoring results. I emailed Brandon and asked to have a supervisor contact me so that we could discuss further, because the implications of being removed from an exception would be very large and would put us in instant NOV, given the fact that we had started monitoring and understood that we were in exceedance. Our boilers were not capable of meeting the standards, which we did not understand before. I was given an email back, which I can find and send to someone at a later time, and I believe it was Brandon's supervisor, or that stated that there was no reason to meet and that we could put that information into the hearing board during our hearing.
Okay, so going forward, are you going to have individuals who will be responsible for these reports specifically?
Yes, ma'am. I would be the person responsible. Yes.
Okay, so you're going to be the person who's going to be now submitting these reports to the AQMD, correct?
Yes, ma'am.
Okay, thank you.
Mr. Balagopalan.
Thank you. Morning, Ms. Simmons. You realize now, however, that you're no longer under that 5 pound a day exemption, right?
Yes, sir. We realize now we are no longer under exemption.
And that you have to calculate those emissions daily. I mean, if you're trying to keep it below 5. So and I think that's the reason for the condition to take readings using the calorimetric tubes so that you can calculate your daily emissions. Is that your understanding?
Yes, sir. Yes, sir.
So, and you're familiar with the method 307-91?
Yes, sir. This is a gas chromatographer method. I have it in front of me.
Okay.
We are not capable of performing that test in our lab, but I am familiar with it. I know that it has to be collected and analyzed within 24 hours. And we currently have Quantum Analytical Services performing that for us on a quarterly basis since Brandon brought this to our attention.
Okay. Now, I also wanted to bring it to your attention that it does refer in the Rule 431.1 to Attachment A, Section 3. And there are a couple of steps you have to do before you go to the calorimetric testing. So I'm assuming you're taking that, that has been discussed, because you have to do the correlation.
I will make sure that that's done, and I will make note of that right now. And no, sir, I was not aware of that before, but we did look into our proposed variance conditions, and we do have some time where we'll be starting on January 5th with daily analysis, and then we start the week to December 20th. So before our first sample date, I will look into this and see how we're going to meet those conditions prior to beginning the calorimetric testing.
Also wanted to bring your attention to another condition in the rule and wanted to find out if you need to add that to the variance request or maybe not. But it's specifically, I don't know if you have a copy of the Rule 431.1.
I can maybe bring it up in my computer real quick. I should have it on file. I have a lot of rules, but that one's not here. I'm not sure why. I can bring it up from the internet.
Yeah. Okay. Specifically, I was wondering, and maybe I'm reading it incorrectly, but E4 of that Rule 431.1, it's on page 4 at the very bottom.
Okay, I'm bringing it up right now. Okay, I'm on page 4.
Page
Yeah,
4.
at the very at the bottom, the 4, it says previously exempt or previously compliant facility, which is what the facility was. You were previously exempt because less than 5 pounds a day, but then you've exceeded the 5 pounds per day. So there's some timelines in there when you're supposed to submit a plan, submit application, and so forth. And I think those deadlines have passed. And I'm just wondering whether you need to add that, and maybe Mr. Thomas, so we can,
And Mr. Balagopalan, we're going to take a break in a couple of minutes, and we can have petitioner look at that on the break, and that way we don't have to take the time right now, but then they can consider whether or not they believe they need it. Mr. Tomasova can do the same, and so can the board. Okay. A4.
I would appreciate that. Thank you.
Any other questions before we do take a break?
Just one final question.
Mhm.
Ms. Thomas, do you know if there's a process in place to reduce sulfur emissions in the treatment process, wastewater treatment process?
I believe Mr. Watson has already answered that, and I could refer that also to our Wastewater Operations Superintendent, Fernando Mata, if you can reserve that question for him.
Okay.
And he
All right. Thank you.
Any other questions other than with regard to that additional A4 section of 431.1, which petitioners will look at over the break? Any other questions for this witness? Okay, thank you so much for your testimony. Let's take a 15-minute break, a little less than that. Let's go off the record and come back at 10:45. And hopefully we'll have an answer to that last question, and we'll take the next witness at that time. We are off the record. Oh, and please don't leave the Zoom meeting, but do mute your microphone if you do not wish to be heard during the break. And you can also turn off your camera if you wish. Okay, we're off the record, and we'll be back at 10:45. It is 11:45, so if we can begin assembling. I'll wait till we have everyone present. Okay, we have both parties and we have all board members. Okay, and Madam Clerk, are you back? Oh, Teresa, are you back?
I'll check on that.
Okay, thank you, Faye. Oh, great. Thank you. Okay, we are back on the record, and when we left off, there was a question remaining for Ms. Simmers, and also if Mr. Tomasovic has a position regarding 431.1A4 and whether a variance needs to be sought from the provisions of that rule. I don't know, Ms. Simmers or anyone for petitioner, if you have an answer for that at this time.
I would respectfully ask more clarification on the question. We've been reviewing that particular section, and I just want to make sure I'm giving you the answer that you're requesting.
Do you want to rephrase or restate your question, Mr. Balagopalan?
Yes, the rule requires that if you're out of compliance, you were previously exempt, and because you were less than your emissions were less than 5 pounds per day, but then the exemption went away because you exceeded the 5 pounds per day. So this section says that if you were previously exempt, and then now you have to submit within 30 days, a plan, time exceed a plan to demonstrate compliance, submit an application within 6 months, and then demonstrate compliance within 18 months. So I just wondering if those timelines have exceeded, or if you need relief from that section also with this variance, so you're not in, that it's not added to the violation.
We would request relief, given the fact that we're under a variance, and our.
Is that your, okay.
If I could interject, it also
Yes,
might
I was going to ask Mr. Tomasovic.
So we wouldn't object to that, and also we don't generally object to the notion of giving a broad variance for 431.1 requirements, more so in their entirety. This is a cooperative facility. When it comes to that specific provision you're looking at, you get into some maybe evidentiary complexities where we can say we don't oppose the granting of the variance there. At the same time, if tables were turned and we were pursuing an order for abatement, we wouldn't necessarily assert an affirmative case about when that timeline started or when it passed. We did, I can just mention parenthetically, we did look at E4 for that outer bound timeline of the 18 months for when compliance should be shown for a facility. And we think that that's an appropriate outer bound for this facility, even though they have had some time to already get to this point. But that's our concept of a cut point. I referenced other parts of 431.1. If you look at our proposed conditions, including condition 13, where I had asked some questions about future monitoring options. So 431.1 does give these options to a facility. We have some skepticism about what will ultimately be technically compliant with monitoring once that control system is in place. The real purpose of the monitoring conditions in condition 7 and 8 is mostly to see that the facility has the option and capability to pursue an alternative monitoring plan. So if I called staff to explain it, they would say for most facilities, the alternative monitoring plan is the most cost-effective way to go. It's certainly fine at this point, though, to keep it open. And an alternative monitoring plan, I should mention, may include those elements of having some kind of continuous monitoring, a patchwork, if you will. That's more in the realm of to be determined, right? But once that alternative monitoring plan application is in-house and subject to assessment by the district, then you're in a kind of gray area where that's pending the ultimate approvals that require sign off by EPA and CARB as well. And so there's maybe some compliance question as to what does that mean for the facility? Is it following the exact letter of 431.1 for monitoring that's required on an interim basis? But this is, with our proposed conditions, we've devised them as kind of as best they can be done. And we think consistent with the precedent for what it takes for these facilities to ultimately get to that point of having an approved compliance plan. And in the meantime, for any given set of lab results, we believe we could check that there is compliance with the Table 1 emission limits. So there's just some sort of moving parts, we hope moving towards that point when the sulfur control system is in place and they have hopefully their streamlined and favored monitoring system of choice in place for the facility. So hopefully that's responsive.
Is this a statement along the lines of what you began with, that you do not oppose an overall general variance for 431.1 in its entirety?
The latter part of my comments, I think, militate towards the idea of giving a general variance from 431.1 requirements, because if you're going to specifically pick out E4, then you're also maybe raising the question about subsection D for monitoring requirements.
And there may be others you're saying that we're not considering.
Perhaps so.
Okay, so the recommendation or the proposal is instead of 431.1, we would be granting a variance from that rule, and that the proposed conditions would address all of the issues that would otherwise be covered by the rule in the interim.
Yes, at the point where the facility has the fuel, speaking to 431.1 specifically, at the point where the facility has that system installed, and by their monitoring, they're able to demonstrate compliance with the Table 1 emission limits, they may well have that alternative monitoring plan still pending approval. But from a compliance standpoint, the district won't have any concerns about ongoing noncompliance. There is, I alluded to a gray area in terms of that monitoring plan still pending approval, but that's just the way it sort of has to work from an implementation standpoint.
And is there any other part of 431.1 that you are concerned that if it's just included in this variance would be leaving a big hole of compliance that they otherwise should and could be complying with? I understand that they're good actors and you don't have concerns, but as a hearing board, we generally like to be very specific in our variances and not be too broad.
Well, our prime concern is the Table 1 emission limit, and surrounding conditions are supposed to drive them to meet that. And so I think it works either way, either a general 431.1 variance that references the rule in its entirety, or if it were just to reference table 1, I think from an enforcement standpoint, we would think that the facility is on track and it's covered. So I don't know whether that counts as they are on an implied basis also good to go with other requirements and timelines, including whatever wrinkle E4 or C4 poses. So
was it A4 or was it?
I think it's
C4.
oh, sorry. Oh yeah, C4. Sorry, can't read my own writing.
Okay. Okay, thank you. And I will take that all under advisement and consider that in our final decision. Thank you for that. Okay. Any other questions then from Ms. Simmers before we move on to the next witness for petitioner?
I
Yes.
do have one follow-up question for Ms. Simmers. Ms. Simmers, do you have a copy of your permit for the treatment plan? The general permit for the facility?
We are in permit revision right now, so I'm not quite sure what our status is on that. Are you asking about the original or the?
Yeah, the existing one. And I'll explain in a minute where I'm getting with that, because I'm looking at what interim mitigation measures you can take to reduce sulfur emission in the interim while during the variance. And one of what most facilities that I am aware of at treatment facilities, they use some kind of ferric chloride injection or iron sponge, something to reduce sulfur. And I'm kind of surprised that you don't have something in place, or if there's something in the interim that can be introduced as a mitigation measure to reduce, the sulfur emissions.
Yes, as I said earlier, I was going to refer that to Fernando Mata because we do have some sort of treatment, but I am not the expert and I would not want to misspeak. And
Okay.
Fernando Mata, who will be speaking next, will be able to address that.
Okay, that's fine. Thank you.
Okay, board members, any other questions from Ms. Simmers, or shall we move on to the next witness? Okay, and I assume Mr. Ali does not have any questions. No, thank you. Okay, then you, Mr. Harris, whoever's going to speak next may introduce themselves and just begin by stating and spelling your name for the record, telling us your title and indicating that you did take the oath this morning.
Sure, and as Shannon mentioned, Fernando will be the next to speak, mainly on sulfur reduction and operations at the plant.
Good morning, everyone. Fernando Mata, F-E-R-N-A-N-D-O M-A-T-A, and I have taken the oath, and I am the Wastewater Operations Superintendent.
You may proceed.
In regards to the question, what have we taken to reduce NOx? We do have ferric chloride injection into our biological process.
Just as a SOx, you meant, not NOx. The ferric chloride reduces SOx, not NOx.
Yeah.
Okay, just clarification.
Correct.
Okay, thank you for that. Do you have anything else you wish to testify to for the record before we move on to questions?
Negative.
Mr. Tomasovic, any questions?
None at this time.
I do, Ms. Bruzak.
Sorry, I was. Mr. Mott, I just wanted to ask, would you be the witness who would testify as to excess emissions? Did you hear that? I'm sorry.
What was that?
Would you be the witness who would testify as to excess emissions that would result under the variance?
No, that would be Shannon Simmers.
Oh, okay. Then let's just, we'll take questions for you and then we'll go back to Ms. Simmers. Mr. Balagopalan, you have a question.
Mr. Mehta, so you mentioned that you are injecting ferric chloride specifically to reduce the sulfur emission. Is that correct?
Correct.
And in the interim, during the variance, can you increase the usage of that to reduce the sulfur generation
Yes, absolutely, we can.
without exceeding your NPDES limits?
Yes, that wouldn't be an issue.
So that you will be willing, if Mr. Musek is okay, to add a condition to increase your ferric chloride injection, and then and of course you're doing monitoring already as a condition, so you can see the impact of doing that during the variance.
Yes, we do. As I said, we do inject the ferric chloride. We do monitor. Toxicity of the sludge is also monitored, and we can increase or decrease the ferric chloride injection.
Okay, thank you very much.
Can you spell that word either? Can you spell it actually, Mr. Balagopalan? It's perchloride. How does that spell?
Oh, ferric, F-E-R-R-I-C. And it's chloride, C-H-L-O-R-I-D-E.
So it's
and
only
it's typically a normal operation at a wastewater.
Is it only one? Oh, it's two words. Ferric.
2 words, sorry, yeah.
Chloride.
Chloride,
okay.
Yeah.
For Mr. Mata, I don't have exact wording, but it would be, if we added a condition, it would be that petitioner shall either increase or decrease or adjust injections of ferric chloride as necessary to reduce SOx emissions. Would that be?
Sulfur emission, yes. Mm-hmm. The generation of hydrogen sulfide, yes. But I think overall it's sulfur, so yes.
It would be to decrease H2S emissions?
Yes.
Okay. Okay, thank you very much. Any other questions then for Mr. Mata? Okay, then we'll bring back Ms. Simmers. And Ms. Simmers, we haven't heard, we have it in the petition, but if you could just put it on the record through testimony, the excess emissions of NOx and SOx as you've calculated them.
We have done some initial testing to establish what our excess emissions estimated for NOx and SOx. In pounds per day, it is estimated that we would exceed by 0.25 for NOx and 0.08. And because we did not indicate any mitigation measures in our petition, we do not have an after mitigation, but given the condition that is proposed today regarding the increase of ferric chloride, that may change, and we would only know that through monitoring and seeing any reduction.
Thank you for that. Mr. Tomasovic, any questions on that testimony?
No questions.
Any questions? I don't have any. I thought I had one. Any questions, board members, for Ms. Simmers on excess emissions or anything else that she has testified to at this point? Okay, thank you, Ms. Simmers, for adding that to the record.
I'm sorry, Madam Chair.
Yes.
I think since Ms. Simmons is on, and I wanted to bring attention to condition number 17 of Exhibit A.
Yes, sir.
And I know the flare is shared with another facility, but when you're looking at excess emission, would you be also including the flare emission, excess emission due to H2S, sulfur emissions from the flare?
No, I would only be including what we agreed upon as the conditions of the variance, which would be the boilers. The flares under a different permit, they calculate and do testing as well
I
already.
thought I heard Mr. Brian Thomas say they, for the purpose of this variance, they're considering both as one facility. And so I don't, so I just heard a question whether in that situation, whether we should be looking at also the excess emission from the flare operation.
To interject,
It's
we
my
don't
understanding
know
that
we don't know that flare to be in violation of its applicable sulfur limits from the Rule 431.1. So it's not our stance that that would have excess emissions coming from that combustion point.
Okay.
Thank you. Any other questions for Ms. Summers? Okay. Mr. Harris, is there anyone else you wish to introduce to give testimony today?
Yeah, a couple of other witnesses that I think can be brief. There were a couple of questions about reporting assistance and equipment performance guarantees that I think are best answered by our consultant. So I'd call Marcos Padilla with Montrose Environmental to answer those specific questions.
Okay.
I believe he's not in the room, but he's on the Zoom call.
Mr. Padilla, are you on the call?
Yes, I am. However, unfortunately, my internet gave out a little bit ago. So because I called in, I don't think my video feed is available, but I'm still available via phone.
That's fine. Can you just state your name, spell it, and tell us your title with whatever consulting company you are with?
Sure. So my name is Marcos Padilla, and that is spelled MarcosPadilla. I am a project manager for Montrose Environmental Solutions, and I did take the oath earlier today.
Thank you. And do you know that for which Mr. Harris wanted you to give answers?
For one of them, I would like to clarify first off that I am a consultant that assisted with some of the calculation for excess emissions for this specific variance. I do not have the guarantees from the engineers. That would be a different consultation company, the ones that are putting together the package for the boilers. My primary assistance point will be through the permitting side. So in the future, once we set up everything with the city of Redlands, I will be working with the other engineers from the consultant who will put together the package of the boilers to prepare the permit application that will be submitted to the district. Additionally, my responsibilities going forward will be in assisting the district with meeting some of the monitoring conditions in the proposed variance conditions, namely 6, 7, and 8. My consultation company does have experience with monitoring in that respect, and that's going to be the future work that I assist the city with.
Thank you. Mr. Harris, was there other questions you thought that Mr. Padilla could answer?
Those are the two specific questions that caught my attention, but obviously he's available to answer additional questions.
Okay. Mr. Tomasovic, did you have any questions for Mr. Padilla on that testimony or any other questions?
No questions, thank you.
Board members, in particular, Mr. Balagopalan, since I think those were your questions.
Mr. Padilla, I think Mr. Watson testified for the condition 13. There were 3 options to do the monitoring, and he said continuous monitoring. I'm not sure if it was the C1 or C2, continuous emission monitoring or continuous fuel gas monitoring. Do you know what is the proposal?
I'd have to talk with the other engineering consultation company to confirm that. I know part of what we're looking at through our side is to see if we can qualify for the alternative monitoring plan. If that becomes feasible kind of going forward, we'll explore that option as well. But I would have to ask that question once I meet with the other engineering consultation firm.
Do you have any experience with the fuel gas monitoring system?
Mostly on the review and reporting side, but not with the setting up or permitting, not yet, no.
And in review as at other treatment facilities, you've seen that in working properly?
Mhm.
Okay, thank you. That's all I have.
Board members, any other questions for Mr. Padilla? Okay. Were there outstanding questions, board members, that we should see if another witness might be able to answer?
The only, I think there was going to be a witness who was looking at the boilers. I just, because
About the
it
guarantee
says
with regard to burning.
digester gas and whether they have the warranties or the,
Mr.
guarantees.
Harris, sorry. Mr. Harris, do you have any witness today who might be able to speak to the boilers that you intend to install and whether or not there are those warranties or an understanding that they can meet the emissions limit using digester gas?
Not specifically to add information that Mr. Padilla provided already.
Okay.
I do have one final witness, though, who might offer a unique perspective. When you're ready to have that person introduced, I'm willing to do that.
Okay, let's do that. And then we can see if anyone needs to hear from a district witness, and then we can conclude. So Mr. Harris, go ahead, if you can introduce your final witness.
Sure. Our final witness is Chris Boatman. He's a city employee. He's the Director of Facilities and Community Services, and he oversees the operation of the landfill. We've had a lot of discussion about the flare and the fact that there are two unique operations that are being considered as one entity. And so I'd like Chris to offer his perspective on some of the conditions in the variance request. Chris, I think he's on the call. I'm not seeing a video, but I do see his name.
Yeah, thank you, Madam Chair. Sorry, I was just waiting to be prompted to speak, but I appreciate the time to briefly address the board. My main request for the board's consideration is that the landfill be omitted from conditions 4, 5, and 8. And the basis for that request is that up until Tuesday, this has really been, at least from our end, primarily an issue with respect to the wastewater treatment plant and the violations on the boiler. When this condition came up, we had the opportunity to briefly speak with AQMD staff, which we really appreciate. But as of today, these are two separate facilities with two separate facility IDs. There are also two separate permits under AQMD. The landfill is in compliance. We have no violation to date. And while we do share the same flare, the gas is transferred to the flare through two separate inlets. So in our view, this really is an issue that is specific to wastewater. In speaking with AQMD staff, it seems that there is a future desire to potentially combine the facilities into one permit. We feel that this is a future discussion. It may have some implications for both the water and wastewater side, which may necessitate some operational changes if that does occur. But again, as of today, it's two separate facilities, and combining permits would need future analysis. So that's my request today. If the board feels that the condition needs to remain in place, that the landfill undergo the testing that's been specified, we are prepared to comply with that.
Thank you. Mr. Boatman, can you just, before I move on to Mr. Tomasovic, can you confirm how your name is spelled for the record, please?
Sure. My last name is Boatman, and my first name is, first legal name is Christopher. So Christopher.
And you are the Director of Facilities and Community Services?
Correct.
Okay, thank you very much. Mr. Tomasovic, do you have any questions for Mr. Boatman, and did you have a perspective on what he's presented?
Yeah, I'll proceed with questions, Madam Chair. Hey, Mr. Boatman, are you familiar with the AQMD definition of a facility in Regulation 13?
I am not.
Okay. I have it on my screen, and I'll just I thought I had it on my screen. Hold on a second. Would you say that the facility is immediately next to the landfill site is immediately next to the sewage treatment plant?
There's components of the landfill that date back 40 years that are directly adjacent. The active face is across public street.
Okay. And the public roadway there on both sides, you have city property, is that correct?
Correct.
And these are under both ownership and operation of the city of Redlands?
They are, but just one distinction is that they're two separate funds, both subject to Prop 218, and ratepayers are charged separately according to each. So while they're both city entities, they're again treated as separate funds, separate operations, both subject to Prop 218.
Okay. Have you ever heard of facility ID 800411?
I'm not familiar with that facility ID.
Does the landfill have a facility-wide permit, or does it have individual equipment permits?
My understanding is a facility-wide permit.
And just to confirm, the landfill does generate sulfurous gases that are combusted at the flare?
Yes.
And that flare is shared with, or it receives some sulfurous gases also from the wastewater treatment plant?
Yes. And we do source test that annually and test quarterly under our permit at the landfill.
And to the extent that district inspectors came and looked at you for compliance with 431.1, would your operations be prepared to look at those conditions and follow those conditions, Rule 431.1?
I would need to analyze that. Again, this condition was just brought to my attention early this week, and I would really need to probably do some analysis on future implications of that rule.
And do you have pending permit applications for the facility?
I do, and that's one of our concerns with having the facility combined into one. We did submit an expedited permit for a new flare about a year ago, and as far as I'm aware, that permit was moving along at a normal pace until the issue of the boilers at the wastewater treatment plant really came to light, and at which point we were notified that our permit application to replace the flare with a new compliant flare for future compliance, I should say, was put on hold. We have put some calls in to AQMD staff to try to get clarification on that and to see if there's any resolution or way we can continue to move forward with the permit for the flare replacement. But again, we're still working to schedule that. But having one facility does have these types. My concern is these implications could come into play where if one facility has a compliance issue, it may affect the other, which is why our hope was to have a future conversation and a process and looking at the best way to address that.
Right. Is it your understanding, or have you heard that the flare permit application that you have pending is partly put on hold because of the compliance issues at the neighboring wastewater treatment plant?
Yeah, we were informed that that's why it was put on hold.
Thank you. That concludes my questions, Madam Chair. I suppose I would have argument in a closing statement, or I could give comment now, but
I think I'd like to hear, because my understand, and I think, so this way we can get all the facts we need out, but the petition only mentions the boilers. So if we were to grant a variance today, it would only cover the boilers. So if the flare is out of compliance, that would be separate. So given that, do you still feel the need to include the flares in that facility?
a couple things. If I were to call a district witness to testify, they would say that the facility ID that I recited in my questions actually is been around for a while, although it hasn't been assigned to individual permits as yet. It is just in recognition of the fact that on a permitting basis, so this is regulation 13 that doesn't have anything in particular to do with the variance, but it's that definition of a facility. There's no good argument for why these two facilities aren't one facility for regulation 13 purposes. When it comes to rule 431.1, you have the same term, facility, although no definition of a facility specifically provided in the rule. But you do have the fact that these both of these sites are actually doing the conduct that falls under 431.1. That is, they are combusting the gaseous fuels that have sulfur compounds in them, not natural gas. And once a facility falls under 431.1, it is necessary for it to conduct all the monitoring that applies on a facility-wide basis operationally. So this goes back to what I said in my opening statement. So staff, the compliance problem that we've identified in terms of excess emissions pertains to the boilers. The flare under Rule 431.1, Table 1, has a higher assigned emission limit, and we don't have any current evidence that would suggest that limit is being exceeded, but it's still necessary once the facility falls under 431.1 that appropriate monitoring continues on. And part of what is in condition 8 as pertains to the landfill is to make set it on a course so that the landfill as well as the wastewater treatment plan can have perhaps that alternative monitoring plan that does have streamlined monitoring down the road. So we understand that the landfill will have some monitoring costs imposed if our proposed conditions are put into effect. But those monitoring costs will be of potential aid to the landfill down the road, where they can potentially go to sampling at a lesser frequency or testing at a lesser frequency once it is demonstrated that the sulfur contributions of the landfill are not problematic in terms of meeting overall emission limits.
Can we then bring on the district witness that you were mentioning before? Because I think the question would be, could they be cited under 431.1 for not keeping records, given how the district is interpreting 431.1 and this facility? And would they be cited? So if that's the case, then we would need to include the flare, and we would need to include it for total coverage. But if not, then maybe it's not an issue for this particular variance.
I would say if the variance is not granted today, there is a possibility that the landfill operations might be looked at and included in a order for abatement that we'd pursue. So I can't say that we have enforcement witness we can put on that can say that they have deficiencies in monitoring under 431.1. But we could, there's a possibility that it could come to that. The main reason, again, if I call the permitting and engineering witness, what they'd say is the reason why monitoring is needed at the landfill is so that ultimately there is an appropriate, technically compliant alternative monitoring plan that works for facility-wide for 431.1 purposes, that works for demonstrating compliance. And the generation of sulfur at the landfill has implications for what's ultimately approvable across both facility IDs. And the fact that a facility might have separate facility IDs, that's something that's administrative that can be done for clarity and permit record keeping. I don't think that was the intent of having facility IDs in place here. I think more so it was a recognition that maybe over a decade ago, these facilities should have had facility ID 800411. It just hasn't been implemented on the face of the permit side of things. So.
Okay, so let me just ask Mr. Harris. Mr. Harris, is it the overall petitioner's position that you are opposed to including the landfill side and the flare in the conditions of the variance, the proposed conditions of the variance?
So I think Mr. Boatman spoke well. We don't want this to be a deal breaker, that's for sure, but we just have a difference of opinion on what constitutes a facility, and honestly, I don't have the definition in front of me either. We would just ask for your consideration in that regard.
Okay. I think if there's no agreement of the parties, then we will have to probably read the definition of a facility and hear arguments on it. Because we can't force under a variance any petitioner to do anything they're not otherwise required to do under the rules and regulations. So we would have to come to the decision that in fact they are required to do so under the rules and regulations. Can you tell us under regulation 13, what specifically where we find the definition of a facility?
I believe it's rule 1302P.
Would it help to facilitate things, Mr. Tomasovic, to bring on the witness who perhaps could walk us through that?
I can read the definition now. A witness would do the same thing. A facility means any source or group of sources or other air contaminant emitting activities which are located on one or more contiguous properties within the district in actual physical contact or separated solely by a public roadway or other public right-of-way and are owned or operated by the same person. And then there's some further language, but that's the pertinent part. Okay. So our permit position, as well as I think our enforcement position, is these do count as one facility, notwithstanding any history of having separate facility IDs. The fact that there is a roadway is something that's in the definition, but if it is just a roadway, that's not enough to take you out and to say that they are separate facilities. So,
okay, we'll take more argument at the end, I think, but I think that was very helpful so that we know what we're talking about. And it was helpful, thank you, Mr. Harris, that while you disagree, you don't want this to hold it up in and some other issues, which we can discuss in deliberation, and which I will hope that the parties will state in their closing statements. Any other questions we need in terms of facts or information we need to gather before we see if there's any public comment, take closing and deliberate, board members? No? Okay. Thank you then. And thank you for that testimony, Mr. Boatman. Okay, I'm going to ask then if there's any member of the public who is present on this matter and who at this time wishes to be heard. And if you do, you can, if you're on a PC, then you just hover over your screen, go to the bottom, you'll see a raise hand. Think something button you can press. And if you're on a phone, you can also look to the bottom, and I believe there's a raise hand button. You can indicate any other way and let me know now. We can take that public comment. I'm just looking to see if anyone is indicating they wish to be heard on this matter. And I do not see anyone who wishes to be heard. Thank you very much. Mr. Harris, if you could give us a closing statement, if you wish, this would be the time to do that.
Again, I just want to repeat what several have already said. We appreciate your consideration of the variance request. I think we have a workable document. I'll reiterate the fact that we would like you to consider the removal, as Mr. Boatman pointed out, of the flare and consideration of those entities as being separate. Hearing the definition of facility, it seems that may not be possible. We definitely do not want to make that a deal breaker or hold up our variance approval or consideration of the approval for that issue. We intend to be compliant, quite honestly. If you elect to revise significantly in some way the conditions or not grant the variance at all, we are on path to become compliant irrespective of whatever conditions might be imposed. I like the word or the description of the city of Redlands that I heard as a good actor, because I'll say again, I've been here a week and a half, and I'm here because the city of Redlands, they're a good actor community, and it's a great place to work and live. They were already miles ahead of me before I landed here a week ago in terms of coming on board with compliance. Appreciate the effort of the AQMD staff, particularly Brian, and working with our staff openly to produce a document that I believe we can all live with.
Thank you. And Mr. Tomasovic, you're closing, and if you also could tell us if we decide to include the landfill as well, if it's just the flare in where we find the device number, et cetera, for that, so we could, if we were going to include it.
You're muted. Mr. Tomasovic, you're muted.
Thank you, Madam Chair. Staff, if you have I know you're on and listening to the proceedings, if you can email me the device number and the facility ID for the flare, that would be appreciated. Moving into a closing statement, though, I think we would have serious concerns that the monitoring will be technically appropriate and appropriately comprehensive under Rule 431.1 if the landfill is excluded. So the basic situation is the boilers were looked at for non-compliance with the Table 1 emission limits. The facility testimony conceded today that 431.1 limits do apply for sulfur. And we're looking at a situation where G8, the exemption that they may have assumed to have fallen under in the past, or may have laxly considered, gave them some benefit in the past, cannot be demonstrated to have been in effect or continuously maintained all this time. So the G8, it's been referenced in terms of the facility-wide 5 pounds per day of sulfur limit, which is at the back of the rule, that can be of aid to those facilities that are below 5 pounds in terms of they don't have to do anything under 431.1. So we have I think a firm enforcement position that 5 pounds per day is something that needs to be satisfied, obviously with the flare, because that's part of what's being generated at the wastewater treatment plant. But that flare is also shared and happens to be shared with the neighboring landfill that's also generating sulfur gases that would fall under 431.1. So what the facility needs in terms of coverage and to ultimately be in compliance, as we see it, is number one, fix things on the wastewater treatment side in order to comply with the applicable limits for the boilers. Ramp up monitoring on a facility-wide basis in order to assure ongoing compliance with the flare. There's just not a baseline of data as required by 431.1 for us to be in a position to say that the flare can get by with lesser monitoring. And it is, it's just folded in because 431.1 happens to be not just an equipment basis type rule, but it's also what is the definition of a facility under 431.1. And in this case, I think it's not just logically necessary that you look at all sources of sulfur, including what might nominally go under different facility IDs, but also ensure that the monitoring as required by 431.1 is ultimately put into place. And so our assumption is that they would be looking at the alternative monitoring plan. And this kind of ramped up monitoring is ultimately what we need, EPA need, and CARB would need in order to be able to sign off on something that would let the landfill or even the wastewater treatment plant revert to something more lax. However, even in the terms of our proposed conditions, we preserve these options. If they have a technically compliant continuous monitoring system, a SEMS, or a technically compliant continuous fuel gas monitoring system at the appropriate points, then they may also be good to go. But we also don't have the application that would be before our staff to review to make sure that they're good to go with those things. And so in the absence of any of the monitoring that would be ultimately conducted under condition 13, that's why we need condition 7 and 8 in order to have a basis for them in the future to fall under something that works under condition 13 and 431.1. So I know that was narrowly focused on one aspect of things, but we do think, subject to the adoption of our proposed conditions, that the facility will be on a path to meet all the pertinent rules that we've talked about today, and that this is the most expeditious way for the facility to move forward and put in controls that will benefit the public. And I do think I'm glad that our technical staff have been observing the proceedings too, because I do think there may be a need to be proactive and ensure that these permit applications have everything they need. We cannot really bind our permit folks to a particular timeline and getting those permits out the door. So that's part of why, even as the facility has these great aspirations to get into compliance sooner, it's just not something that on our end we're able to make assurances that they can have that ideal timeline. But I do think staff will work diligently to try to get this facility compliant and hopefully get that facility in the quickest time to satisfy condition 18 and notify the clerk of the board that final compliance is achieved. Thank you.
Thank you. Before we deliberate, I had one question for Mr. Tomasovic and one question for Mr. Harris. Mr. Tomasovic, your position is to include flare. However, condition 1 of the proposed conditions says this variance shall apply only to the boilers, which are identified in the petition. Should we remove, the variance will be very clear what's included once we deliberate. Should we remove condition number 1? Oh, you're back on mute.
That may work, Madam Chair. Staff has also emailed me to tell me that the flare is actually listed. The permit is listed in conditions 7 and 8. So let me just confirm.
Ah, okay. It doesn't have a, does it have a device number? Do we need a device number?
No, it's got a permit number, so that's sufficient.
That's by itself. Thank you, Mr. Balagapani. Okay. Okay, thank you. So that answers that question. I had a question for Mr. Harris. Ms. Verdugo Peralta had asked whether you would agree to a condition to submit a Gantt chart within a reasonable time frame. Do you have an idea of what that reasonable time frame is so we could place that into that condition? And in fact, I think that would be an increment of progress. And I've identified a number of the conditions we could make increments of progress.
We would have to talk about that as a staff, but if you're talking about a Gantt chart that gets us to final compliance, is that the question? Can I ask for clarification?
Is that, I see Ms. Verdugo Peralta saying yes. Is that what you were looking for?
Yeah, the Gantt chart is like a living document of the progress and all of the points of interest that they need to come into compliance and to let us know and watch that progress.
It wouldn't hold you to.
So I think we could. Yeah, I think we could submit, an initial chart within 30 days, and I guess I'm looking at staff to see if that's reasonable. And obviously, we'll continue to update and provide you those updates throughout the term of the variance if it's approved.
Okay, thank you. Okay. All right, board members, that means it's time for us to begin deliberating. And what I'd like to do is, again, bring up the variance findings we need to make and the health and safety code sections, which are also relevant. So I'm just going to share my screen to begin. In the right document. Okay. And if you can see that, Health and Safety Code 42352, we know the 6 findings we need to make. We can go through them all when I stop my share, but I wanted to just raise some additional considerations for this matter, which will also inform our deliberation. First of all, as to the second finding with regard to beyond reasonable control and arbitrary and unreasonable taking of property, we are informed by the Health and Safety Code that in making those findings, when the petitioner is a public agency, the hearing board shall consider whether or not requiring immediate compliance would impose an unreasonable burden upon an essential public service, which would include, sewage treatment works, as well as landfill gas control. So if we were to include both, they are both in there for that consideration. In addition, I also wanted to raise for the hearing board's consideration Health and Safety Code 42352.5, which tells us further that in determining whether or not conditions exist which are beyond the reasonable control of the petitioner, the hearing board shall consider the extent to which petitioner, and I underlined it because I think it's relevant here, took actions to comply or seek a variance, which were timely and reasonable under the circumstances. So I just wanted to bring that up, and I will stop the share. And would anyone like to begin the discussion of the 6 findings? Mr. Balagopalan?
No, I can provide some background on the unitized ID that Mr. Brian Thomaswick, alluded, and whether, why. A little bit of background after that, and on those IDs. And normally a large facility may have been broken up into individual ID, but they have an umbrella. They're under the umbrella of the main ID, which is the 800 unitized ID. You'll see that at refineries, UCLA, and other facilities. And that was done mainly to facilitate some of the companies, like I think Mr. Mr. Simmons or Mr. Harris mentioned, they for budgeting purposes, they separate budgets and so forth, but there's still the new source review and stuff, and it's all accumulated under one unitized ID. So while they may have individual ID, they're still aggregated back to the main ID for new source review purposes. It was done mainly for billing and convenience purpose. Some large facilities inspectors were easier to break it up so they can go inspect a set of equipment and they can check it off and then go back to the next ID and look at those. So it facilitated inspection. So for that reasons, the 800 ID was created. But I think the definition of facility, my reading and it was from the others, I would say yes, it does fall under a facility definition, and I think the district had already aggregated it, had created 800 ID, so I think it's appropriate to leave it at that.
And thank you for that, starting that discussion. Let's start on that. I also agree that given the definition, the landfill also falls within the same facility under Reg 13, as does the treatment plant. And so for that reason, I would want to include it, but also I think in this matter, when we talk about the 6 findings, I think I will be able to find beyond reasonable control, but I think it's only because this facility is an essential public service. Otherwise, I would struggle. And so based on that, and based on Mr. Tomasovic's representation that if we didn't grant a variance today, the intention of the district would be to seek a comprehensive order for abatement, which would include both facilities and the desire to make sure that overall sulfur emissions in 430, and also one other thing that Mr. Tomasovic said, which is, I don't know that we would go with this, but that he is not opposed to an overall variance, which includes generally 431.1. So if we're going to do that and both facilities fall within that, then I think both facilities need to be under this variance. So I'm in agreement with Mr. Balagopalan. Anyone else have any thoughts on that before we hit the 6 findings? Okay. So let's just go through them. I think, as I was saying, I think I can make the findings. Obviously, there are, given the emissions of NOx and the sulfur emissions from the boilers and the other processes that have been talked about today, are in violation of several rules, which include the new rule 1171.1 for NOx and
1179.1. I'm sorry, Madam.
Did I say that wrong? I have it written.
Yeah.
1179.1. Thank you. And 1146.2, which was existing before, but as I understand it, has been moved over. Also, portions of the permit, as well as 431.1 with regard to sulfur. So certainly the first finding can be made. Second finding with regard to beyond reasonable control. As I was saying, I believe that if this were any other kind of company, not doing an essential public service, not a government agency, the fact that there were NOVs, and for whatever reason, a lack of understanding that no longer did the exemption apply, I would have a hard time with that. But given the additional considerations we need to make with regard to the fact that this is a public, essential public service, and it is, as we said, a good actor otherwise, as soon as, and that was the other consideration, as soon as the city found out that it in fact was in violation and received the NOV, it immediately started expediting plans and trying to come into compliance. And in fact, one of the witnesses stated that they were in discussions with the district, doing this in hand with the district. And so for all of those reasons, I do believe that I can find beyond reasonable control, and that it would definitely be an unreasonable burden on an essential public service to take those boilers out. We heard testimony and we saw in the petition that there's a lot of sludge, and we're talking about per month, almost $2 million per month to just haul it off, if that's even possible. And certainly having upset conditions, et cetera, if they couldn't heat the sludge to the temperature that is required by the boilers. So I can make that finding. Let's stop there though, and see if there's additional discussion with regard to the second finding, which I think was the more difficult one. Mr. Balagopalan.
I agree with everything you said. I think the facility was under the mistaken belief that they were exempt from 431.1, and that they didn't have to keep records or show that they were daily below 5 pounds per day. And I think they did probably kept it for a period of time, but then, so even though they exempt, it is implied you have to demonstrate that you're below daily in the rule. So, and whatever reason, they write it differently, so that there's no excuse. But I think by like you pointed out, once they found out that's the case, they did start looking into a better conditioning system and looking at reducing the sulfur content of the gas. So and I also totally agree that it wasn't for a public utility, essential public service, that that consideration, whether that was whether they were beyond the reasonable control. It is, they did keep just same way the exemption was in the boiler too. If you're below 9,000 therms per year, they knew, and they had records of that because they get the bills and so, or gas bills, or they were keeping track somehow the way. So anytime you exceed that, then the exemption goes away basically. So, I think they should have known, but it appears they didn't. But I think they're aware of it now, and moving forward, they will keep diligent records as needed.
Thank you. Any other thoughts? Ms. Verdugo-Peralta.
Thank you, Madam Chair. I was a little bit more skeptical in reference to that, but the fact that, of course, as you've mentioned before, that it is an essential public service, but more importantly, with the assurances of the new director as well as the other employees there, that they are going to be much more diligent about keeping those records, then I can find for that. And I also wanted to say, I know Redlands very well. I used to live and work there for many years, and it's a beautiful town. And unfortunately, during summertime, they get everybody else's smog. And for this public agency to possibly be adding to that, to me, is heartbreaking. So I am hoping that they are going to be very diligent about being a good actor and a good neighbor to the rest of their residents. Thank you.
Thank you for your thoughts. Anyone else wish to comment on beyond reasonable control in the second finding? Okay, then moving on to the third finding, that the closing or taking would be without a corresponding benefit in reducing air contaminants. while the request is for 18 months and it adds up over time, I think looking at the excess emissions, they seem relatively small per day in any event. NOx at 0.25 pounds per day and SOx at 0.08 pounds per day. And as Ms. Simmers mentioned, that's without mitigation. So the some mitigation was discussed in context of the proposed conditions, and in particular, there was a discussion of the training that has been done to prefer digester gas over natural gas to the maximum extent possible. And so while, as Ms. Verdugo-Peralta, I think you're pointing out, it is not inconsequential at all, especially in an overly burdened area, I think I can make the finding that shutting down these boilers or having to deal with that sludge, which is constantly being created, I think I can make the finding that this variance would be without a corresponding benefit in reducing air contamination or not having it. Can make that balance. Any other thoughts on that?
Yes, I can also make that finding. I think the significant harm to petitioner outweighs the benefits to air quality. I mean, the emissions that you mentioned were very small. It's not, so yes. And it's again an essential public service, so it's a wastewater treatment plant, so it's to continue to operate.
Any other thoughts before we move on to the next finding? Okay, curtailment, not an option here. Again, they could, the only thing they could do for curtailment is to take that sludge and ship it out. And we heard testimony that they don't even know if that's a possibility. They create so much sludge, but fiscally or financially, it makes no sense for ratepayers to have to add to that almost $2 million per month. Are we in agreement on that? Any other thoughts? Okay.
Yes.
Thank you. I think reducing excess emissions to the maximum extent feasible, we already talked about that with regard to the third finding, and that in particular, trying to maximize the use of the digester gas over natural gas. But also my motion, should I make one, would include the suggested additional condition that Mr. Balagopalan suggested, which is to increase or adjust or decrease injections of ferric chloride as needed, which would also hopefully reduce sulfur, H2S. Any other thoughts on that? I think I can make that finding with that.
Yes.
And then finally, monitoring will be covered aptly, I think, by the proposed conditions. So monitoring, that finding I can make as well. I see general agreement. Any other overall thoughts before we move on to a motion now, therefore? Okay, I'm going to try to tackle it because just looking at my calendar for an end date, I thought I had one that I was considering. Okay. I'm going to just make it June 15th, 2022. Wait, no, that gets me, sorry, just give me one moment. 14th, let's make it the 14th. 2022, okay. I'm going to offer a motion. In the matter of Redlands City Wastewater Treatment Plant, case number 3976-5, I move that we grant a regular variance beginning today and ending June 14th, 2022, or until final compliance with all of the variance conditions and increments of progress, whichever occurs first. I further move that it will be for the facility at 1950 Nevada Street, Redlands 92373, and I don't have the address, but the contiguous, the next door parcel for the landfill as well. And in particular, it will be for the 2 boilers that are listed in the petition, number 6 on page 2 of the petition, and the flare at the landfill. And I'm looking for that. ID here.
Permit number
Permit
you
number.
need. It's G31625.
Thank you. G31625. And it will be specifically from Rule 1146.2 C7 with regard to NOx. Rule 1179.1. I don't have the specific subsection, but it is with regard to the NOx limits for the boilers, the newer NOx limits. Further from Rule 203B, and specifically condition number 5 of permit F78942 and number 5 of F78943 for each boiler, which requires compliance with the NOx limits, at least of 1146.2. And also, I'm going to include in my motion the entirety of Rule 431.1, but with the understanding, again, that it only covers those pieces of equipment that are specifically incorporated into the variance, and with the understanding, as we stated today, that the idea is not to leave anything out inadvertently, but to have everything covered by, instead, by the proposed variance conditions. And I further move that we incorporate the proposed regular variance conditions that are found in Exhibit A, and I'm going to make several amendments to it. Number 1, I'm going to remove condition number 1. Instead rely on what I just stated the variance will include. And then we'll renumber, but there's going to be a lot of renumbering, so let's go through this. Condition 6, the January 15th date on the first line should be 2021, not 2020. Condition number 7, similarly in A, there is a date of January 5th, 2020. It should be 2021. And I'm going to call upon Mr. Balagopalan. Was there an additional change you wished to have incorporated, something that was not clear? I know there was something.
Well, yeah, I think it says at least each 7 days. I thought maybe every 7 days, you know. But
oh, sorry, that's for 8. Is that for 8 or is that for 7?
Number 7A, 7B.
B, yeah.
7B. Okay, for every. Thank you. So in B, where it says analysis at least each 7 days, it should be every 7 days. Condition 8, similarly in A, has the incorrect date of January 5th, 2020, which should be changed to 2021. And 8B has that same issue where the word each should be every. Okay. Similarly, what is condition 9, which I'm going to be changing shortly, but so we're all on the same page. There is a February 1st, 2020 date. That should be February 1st, 2021. I didn't catch any other date issues, but if anyone sees them, shout them out.
Madam Chair, I do have the ID, the other ID, which is actually in the petition for the landfill next door. So it's 74413. It's in number 5 in response to questions in number 5 in the petition.
And that ID number is included with the flare. Thank you for that. I'm also now going to pull out 1, 2, 4 of these conditions, which will no longer be conditions of the variance under my motion. They will be increments of progress 1 through 4. Condition number 9, with regard to conducting an asbestos survey, that will be increment of progress number 1. Actually, sorry, I'm going to probably make that increment of we'll put it in order, but it will be an increment of progress. But I think the other 2 might come first. What was condition number 13 with regard to the submission of applications to AQMD, that will be increment of progress, an increment of progress, and we'll put them in the right order. I think it should be, well, we'll figure that out. What was condition number 15 will also be an increment of progress. That is the submission of source test protocol. And what was 16 will be an increment of progress, even though it's really coinciding with the final compliance date.
And we will put in there the verbiage regarding
Yes.
chart.
Yes, I have 2 additional conditions. One will be petitioner shall adjust injections. Petitioner shall adjust injections of ferric chloride, spelled F-E-R-R-I-C, second word C-H-L-O-R-I-D. Ferric chloride as necessary to decrease H2S emissions. Period.
Yes.
I don't know where we'll put that, but that'll be one additional condition. And the other will be petitioner shall submit a Gantt chart. I think that's spelled with 2 T's. Is that correct? G-A-N-T-T. Gantt chart within 30 days from the date of this variance to the district. And Mr. Tomasovic, who should that be to the attention of?
Which condition, Madam Chair?
The Gantt chart?
I think the individuals that are in the original exhibit under condition 14,
Okay.
Travis Road and Brandon Illidan, that'll be acceptable.
Okay, Madam Clerk, we'll do that. We're going to be adding in this condition to the attention of the individuals listed in existing condition 14. Everything's going to be all different. And the clerk of board, and the board, the hearing board at clerk of board at AQMD, or wait a minute, clerk of board at AQMD.gov. Mr. Balagopalan?
Madam Chair, since this is a multi-year variance, should we have a progress, an update some point next year, come back to the board and give an update?
Mr. Tomasovic, have you given thought to that?
When I spoke with Mr. Watson, I said if there were any hangups as things progressed, they might have the option of seeking a modification of the variance, but seems early to say that, and I don't know whether anything productive or would come of having a status on meeting things. But it's to the board's pleasure if they wish to put in something like that.
Thank you. I think, Mr. Balagopalan, that this is different maybe than an order for abatement. And since it was the 6 findings that they needed to show us, then they'd have to come back and explain why there was good cause not to meet them. And I think we would put it under a different lens than we would for an order for abatement. If they don't, and just so they understand, and I think they do, but Mr. Harris and others at the city, if we grant this order, it becomes an order of the district, which is enforceable as any other rule or regulation. And so if anything is missed, any deadlines are missed, and a modification is not sought, if a deadline is missed, that is a violation that can be cited. And if the final compliance date is not met, then the variance would end. And there would be no protection unless a modification is sought in a timely manner. With that, Mr. Balagopalan, does that
No, that's fine, yeah.
Okay. So I think that completes my motion with excess emissions being 0.25 pounds per day NOx and 0.08 pounds per day of SOx. Is there a
I'll
second?
second it.
Second.
Yeah.
Okay, I'm going to take Mr. Balagopalan as the second. Is there any discussion on that motion before I call for a vote? Okay. Ms. Verdugo Peralta, how do you vote?
Aye.
Dr. Bernstein, how do you vote?
Aye.
Mr. Ali, how do you vote?
Yes.
Mr. Balagopalan, you vote?
Yes.
I vote yes. Motion passes 5-0. And thank you we went a little bit longer, but that's always, that's almost always the case. But I thought that the testimony was very succinct and to the point. Very complex matter. And good luck in performing under the variance and getting everything in order.
Thank you.
Okay, it would be time then. I know that there's another matter. I know we have many people who are viewing for Chiquita Canyon landfill. I think it's best if we take our lunch break before we start, so we don't have to start it and then take a lunch break. Let's try to take no more than a 45-minute lunch break so we could start promptly at 1, knowing that it's at 2 o'clock. Is that correct, Madam Clerk, that I have the pre-hearing?
That is correct.
So we will have to take a break at 2 o'clock. Hopefully, well, I will limit it to no more than a half an hour. And if we're not done, we'll have to continue that to another day. So we'll take our lunch break. We're going to go off the record until 1 o'clock. So anyone who is interested in the second matter, please make sure you come back at 1 o'clock, and we will start promptly at 1. Thank you very much, and we are off the record. Can you hear me?
You know what? It doesn't have me as a host either, so I don't know what happened when it kicked me out.
I think.
Put us back in what we should be. Let me give Anthony a call.
Oh, I see. I see Paul said he'll do it in just a sec. Okay, he'll take care of it. And if anyone can hear me, also Faye. Thanks, Faye.
Yeah. Okay.
Bye.
Hi.
So I'm so impressed with what you did. What's that?
Hi, Julie. Did you just got on the telephone or? Let me see.
Can you, Anthony, can you hear me?
Yeah, I moved her right now.
Okay, can you change me also to,
What do I need to change you?
I guess I'm okay. I'm usually a co-host, but that's okay.
I got you. Let me
Okay,
put
I got kicked out like.
You got out? Okay, no problem.
Al's a co-host, showing her
Al,
already.
yeah, she's already co-host.
Yeah. For some reason, I think Julie and I got kicked out, and then.
Yeah. I moved Julie back, and I'm gonna make Julie a co-host.
Okay.
Anthony?
Yeah, I see you.
Okay, so I just finished talking to Amir.
Yeah, I know. I saw it.
It's all right if I just run into the CAF and get something and I'll bring it
Yeah,
back?
go ahead and do that. Just go get
I'll bring it back into CC4 and then you can yeah, and then we're good for the day when this is done, correct?
Yeah, we just have one more drive run, I think, which is starting. Technology. Oh no, that was yesterday.
We did that yesterday.
Okay, yeah, I'm looking at it. Okay, yeah, this is a residential.
Like me, I got ahead. I thought it was Thursday today.
Yeah.
Okay, so give me 1 sec. I'll be right back. So Julie's co-host, your host. Perfect. I'll be back in a sec.
She was out earlier. I see Monica Fernandez. Is she supposed to be moved in, Monica? Paul? You're on mute.
She's one of our inspectors, so I think so.
Her over to
Yes.
panel?
Has Dominic been timing people? Faye?
They didn't do it like.
I don't think they used it. Yeah.
Okay, I'll have it ready just in case.
Yeah, if you want to get it ready, and then
Yeah.
that way I could release Dominic to.
Sure, absolutely. Let me 1 sec.
Go ahead and just start your timer.
Yeah, OBS is going. I have it. Okay, so then I got the background. So let me do this and we're good. Okay.
Hey, Dominic, are you there? If you can hear us, unmute your mic, Dominic, before everybody comes back from lunch.
Virtual background, none. Okay, I'm good, Anthony. There we go.
I'll let Dominic know. Thank you, Paul.
Back.
Yeah, I'll give him a call.
Okay, it's about a minute of one, and we can. I'd like the parties and the board members to start assembling, please. See, the parties are here, and just waiting for Mr. Dugo Peralta. Once we have all 5 members of the board, we can begin the second hearing.
I believe Mr. John Perky may be waiting in the lobby. Could he get elevated in?
Yes, and so is Mr. Israel. Okay.
Okay, they both moving in.
Thank you for that. Ms. Verdugo Peralta, if you are present, you could just let us know and we can begin. Waiting on Ms. Verdugo Peralta, because I think I saw Mr. Ali. Is that correct? No, you might have turned back off. Yeah, okay. And if we don't hear from Cynthia, I don't know, Al, if you're calling her.
Yeah, I am calling her, but all I'm getting is her voicemail. So this is my third time trying to reach her.
Well, it's encouraging that she's still here. I see her name because I know she has a lot of internet issues.
Yeah.
Ms. Verdugo Peralta, if you can hear us and we can't hear you, if you want to try calling in. Oh, there she is. Yeah.
I am.
Excellent, excellent. Okay. So then now I see we have both parties and all of our board members and Madam Clerk. So I am going to go back on the record. We are back on the record. It is still December 16th, and we have one additional matter. And I just want to make sure if the parties were not present when I said this, but we will need to break for probably about a half an hour at 2 o'clock sharp, because I do have a pre-hearing that was already scheduled for this date. Excuse me. But I'm going to call the matter of South Coast Air Quality Management District versus Chiquita Canyon LLC, case number 6177-1, which was continued from last week with regard to the proposed stipulated order for abatement. And who is representing the executive officer today?
Good afternoon, Catherine Roberts, along with my co-counsel Mary Reichert on behalf of the executive officer.
Good afternoon. And who is representing Chiquita Canyon today?
Good afternoon, Jacob Dujinski. That's Jacob, last name Dujinski, Dujinski.
Thank you. And for all members of the public who are watching or part of this, either part of this hearing or watching the webcast, I wanted to just remind everyone that we had asked for the parties to come back to the board today with regard to, we didn't take any action on the proposed order last week. We had asked instead that the parties come back with a few additional items and some potential revisions, which they have done. Those revisions are available to members of the public. And if you have not yet taken a look at them, I'm going to share my screen and show you once again how you can access that. Here we go. Okay. And this is how you can access those case documents and exhibits, which include the red line and clean version of the revised proposed findings. You go to the AQMD website, which is www.aqmd.gov. Go to the About tab at the top, choose the hearing board. Then once you're on the hearing board page, select Hearing Board Case Documents link, and you will see all of those documents that I just mentioned available. Just click on it, and you can access it that way. Let me stop the share. Also, we will, since under the Brown Act, we do take comments of the public every time we hold a public hearing that has been noticed. We will take public comment, but we will attempt to restrict that to those members of the public who either have not yet testified or been heard on this matter, and for those who have been heard, to hear only testimony with regard to any changes to the stipulated order, if you wish to comment on that, or to testimony that we do take today. And I will be calling for that at the end of the hearing. I'm not sure how long the hearing will last, but likely after 2:30 today when we reconvene. Okay, and with that, I'm going to turn to the parties, and I'm going to ask, well, first let me mark that we did receive both a red line version and a clean version. And which party did these come from? So I can mark them appropriately.
Madam Chair, they were submitted by the district, but they are stipulated.
Right. But just for marking purposes, Madam Clerk, what is the next numbered exhibit if you have that readily available?
It would be number 2.
Okay. So the red line version, we will mark as exhibit number 2, and the clean version, we will mark as exhibit number 3. We also received, I don't know where I put the printed version. We received an email this morning, email correspondence. Let me just pull it up so that I can identify it. We received it from, I believe it came from Ms. Reichert. And it was from the clerk of the board. Yes, okay. And it came, board members, in an email at 8:30 this morning, 8:28 this morning. And it contains what we will mark as exhibit number 4, which is I think it's 2 pages. Sorry, I have a slow computer at this time of day. 2 pages, and it is an email exchange. The top one is from Andrew Junke at ucla.edu, and it is to Miss Catherine, it's sent to Mary Reichert and Ninez Pont. I'm sorry if I'm saying that name incorrectly, with a CC to Miss Roberts. And we're going to mark that as exhibit number 4. Okay, and with that, I'm going to turn to, Miss Roberts. And Miss Roberts, if you could give us an opening for today and let us know who's going to be walking us through the redlined changes. And I think we'll probably need to have some witnesses also today, but let's start with the opening.
Thank you. So since we have been hearing this matter since it was continued last Wednesday, the parties have been working diligently to address concerns both that were expressed by members of the board, but also members of the public. And in response to testimony that was received both by the district's witness, Mr. Israel, and Chiquita Canyon, the respondent's witness, Mr. Casulo. In respect to that, we have submitted a revised proposed order that we think addresses all of the comments that were received to strengthen this order and to allow for a better framework. Again, the district does view this order as a framework. We acknowledge that although we have received a number of complaints, there have been notices of violation. This is not a simplistic process that can be instantaneously corrected overnight. As all of the testimony that was heard previously did acknowledge, there are numerous variables that go into the correction of this type of violation of an odor nuisance. Things from meteorology and wind patterns, topography, and how the canyon works and how wind works within that canyon and goes through to the affected community in the valley. We know things like temperature and season can play a role. We also know that we heard from testimony that depending on where in the landfill, which cell is being actively filled, likely plays a role. So we are looking at all of those variables, and this order has always been presented as a framework that included immediate action and also intermediate and longer term action. A lot of right now, the longer term and intermediate actions does look at things like gathering information. There is a whole host of information that we will be gathering from the community, both the respondent conducting monitoring, but also hiring an outside expert. And that does continue to be our intermediate path to ensure that we have a permanent solution. But in response to comments, we have taken quite a bit of look at what can be done in the immediate term. We did initially have short-term actions, but admittedly, those that still required things like permitting, outside approvals. And we recognize that some of the comments that said that might not be enough of an immediate term. So we have come back with proposals that we think do address that question, things that can be taken as remedial actions that do not require permitting, do not require separate approval, and that can address odors right now if this order is issued. We've also tried to shorten the time, as the board suggested, of looking at how fast we can get these more intermediate term solutions in place, how fast we can permit, how fast we can get approvals done. And we've continued to strengthen, actually looking at, based on the testimony that we've received, of what we are going to look at for long-term to add additional variables that we need to assess. So we think in all respects, this revised proposed order does respond to a lot of the comments that we've received, both from the public and from members of the board. And we think it is a better order that it can be a useful framework for right now to address this problem in the short term, as well as the immediate and longer term, to arrive at a proposed final solution for this nuisance. As far as testimony, the district does not plan to affirmatively put witnesses on unless the board has specific questions. The district would propose that council could effectively walk through some of the red lines of these changes and describe them, and would propose, if the board would like to hear testimony, would like to have those walk through first to be able to ask more directed questions to any witnesses that the board may have. And with that, I will turn it over to the respondent. Thank you.
Thank you. Before I turn it over to Mr. Dudzinski, first of all, I want to say I think that's probably the most efficient way to do it, is for you to walk us through. And as we have questions, perhaps there could be a witness that could be introduced for each. Also, I neglected, I apologize, you may see that there's a different face on our board today than there was last Wednesday, and that is Mr. Makai Ali. The senator is out today and Mr. Ali is sitting in his place. And I just want to, for the record, go to Mr. Ali and make sure that he states on the record that in fact he was present for either most or all of the last hearing and is prepared today to hear this matter.
Thank you, Madam Chairwoman. And yes, I was involved, engaged in listening attentively at the hearing that transpired last week, have in fact reviewed various materials as sent by the district via email. I did confirm receipt of those documents this morning with respect to the clerk's office, and I'm prepared to deliberate and engage accordingly today. Thank you.
Thank you very much, Mr. Ali, and thank you for being engaged, even though you did not know you would be sitting in today. That was most helpful to have you prepared. That would have been a lot to catch up on. Okay, and with that, Mr. Dudzinski, your opening, please.
Thank you, Madam Chair and members of the board. I would echo a lot of what the district just discussed. You know, since last Wednesday, I think the parties have worked pretty tirelessly to revamp and revise the proposed order in a manner that is responsive to each of the concerns that was expressed both by the board and to the public. You know, specifically, I think the most difficult issue for us to come up with a solution for was the immediate term action. You know, I would just like to recognize the great work that the landfill operator did, you know, within the intervening period, along with their geological consultants and other professionals in the field to identify areas within the landfill that may also be able to accept waste outside of cell 6. You'll see in the proposed order that there is a solution and a condition related directly to that as an immediate action item. We also heard that there may be some issues with afternoon odors and things of that nature. So we've expanded odor monitoring to occur both in the morning and in the afternoon, as well as the locations where that monitoring is taking place. And we've also sought, as Ms. Roberts indicated, to tighten up some of the timeframes for things that are more immediate or intermediate term,
Madam Chair,
applications.
I'm sorry to interrupt, but we have lost one of our board members. If we could hold up for just a moment.
Yes, poor Cynthia in a very bad area. We're going to hold that thought. Sorry, Mr. Jaczynski, and we'll see if Ms. Verdugo-Peralta, when we have her back, missed any of that. While we're waiting, I could ask any member of the public who does wish to address the board. Oh, Ms. Verdugo-Peralta is back, but if you could raise your hand virtually, you know how to do that. Press the button for your raise hand. That way we can start to understand how many people might be addressing the board. Thank you. Ms. Verdugo-Peralta, did you hear Mr. Jaczynski's
No, I did not.
Mr. Jaczynski, if you can just restate your opening or summarize it. Since it's not evidence, I think it's fine. We're going to go through the order. So whatever you wish to restate, or you can just pick up where you were.
I would just quickly summarize that I think a lot of work has gone into this revised order. We do think it's responsive to the concerns of the board and some of the testimony expressed by the public during the previous hearing. And with where I left off is I think that, we're in a very good position. I think the idea of seeing this as a framework is a good one. I think what was expressed last time is the right notion that this is a good first step. And the relative finding here is good cause to actually sign off on this particular order. And so I will delay any further discussion about the particular changes, as I'm sure we'll be getting into that in some detail. I will say that we also do not have an affirmative witness. I think I agree with the district that the attorneys can likely walk through the changes, but we will have Mr. Steve Casulo, the landfill operator, available if there do happen to be questions that are more readily addressed to him.
Thank you. At this time, I'm going to ask anyone who potentially could give testimony today as a witness and any member of the public who also wishes to be heard. I'm going to swear you in at this time. So we do it all at the same time. If you can raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, thank you very much. Okay, Ms. Roberts, do you wish to walk us through? How do you wish to proceed?
Yes, I'd be happy to walk us through. If I could actually take them in reverse order and address what was marked as petitioner's exhibit number 4 very briefly first, which is an email. And this came in response to both a public commenter and a colloquy between board members and that public member that culminated with a board member specifically requesting the district to address a particular health study. at that time, the district was simply not familiar with the study. So we were able to research that matter. And we were able to reach out to the director who manages that health study to get a little bit more information, and have provided their response describing what their health study is, and how it may have impacted members of the affected community, including those who gave testimony. At this time, the district believes that email does sufficiently address the question of the health study that is being conducted by a third party. And so, but we did want to include that just for reference for the board members to answer that question.
And by the way, thank you. I know that the district is not required to do that. We mentioned that last time, and the board appreciates your efforts.
Of course. If I can, I'm turning to the clean and redlined versions of our proposed changes. If I can, I'm actually just going to share a brief PowerPoint that I think would help kind of conceptualize what these changes are. So hopefully you can see this PowerPoint that would kind of walk through what the change conditions are and why we included them and what we're seeking to address in terms of questions or comments that we received or in light of testimony.
And we can see it. Thank you, Ms. Roberts.
So the first one is kind of a grouping of operational limits that can be introduced in the short term. And these are those immediate actions that members of the board requested get reevaluated in light of testimony and in light of needing to take some changes right now. And so the first one is going to be what is now new condition number 4. And it's going to reduce the size of the working face of the Chiquita Canyon landfill at all times by 15% to 85% of their total maximum permitted capacity under the County of Los Angeles issued conditional use permit. But it's actually going to go even further than that with regards to cell 6. And if you recall from prior testimony, cell 6 is the cell that was opened about a month prior to when the district started receiving a high volume of complaints. And at this time, we think it might be a contributor to why we're receiving so many complaints. So the working face within cell 6 is going to be capped at 70% of their permitted maximum. And this is an entirely new condition that we are adding that does not require any permitting, that can go into effect immediately. The second of those is actually condition number 3. And what that is going to do is going to assess based on actual real world conditions as well as weather predictions, what we are considering adverse wind conditions. And this is based on the testimony, particularly of Mr. Israel, who noted that when we get these sort of very slow moving, almost stagnant type air conditions that are in the direction of the Valverde community, that's when we see a high volume of complaints. When we have those conditions, we are going to require the landfill to divert 50% away of the waste they're receiving away from cell 6, which again is that same cell that was noted as likely as a causal factor in some of these odor complaints. And the last thing that we're going to do immediately is we're going to have a responsive factor included into our community odor monitoring. They are going to be doing this daily odor monitoring, and when we are receiving odors in the community, this is going to trigger immediately diverting waste out of cell 6 if there are actual odors being detected in the community. And this will happen without the need for a South Coast inspector to go out to verify complaints and then to talk with the landfill. So we think between the three of those do address the immediate term, short-term operational limits. One of them will happen all of the time without any adverse conditions, and that's reducing the working face. And 2 of them are based on real world conditions, whether it's odors in the community being detected or adverse wind conditions. So the second is that I mentioned in response to board questions, we did want to reduce the timelines for some of those more intermediate steps. We are shortening the time to submit permitting for the larger orchard fans that Mr. Casulo testified about. And we are going to shorten those from 60 days to submit to 15 days. that should help bridge the gap from immediate to short term. And the second is listed in what is now condition number 13. And this is the alternative daily cover, which will be switched away from what is now tarps to an enviro cover like or similar substance that is not actually removed even when new trash is added. So it always covers exposed trash. And that permitting time approval, or not permitting, but approval from the relevant authority will be reduced from 14 days down to 5 days. The next, in response to quite a number of comments from the public, we do feel that we need to strengthen some of our community monitoring and our outreach in the community. So the first is those odor surveillance in the community. We are going to double those. We did receive some public comments saying that even though we may not receive as many complaints, they are still experiencing odors in the afternoon. So we will conduct those surveys in both the morning hours and in the afternoon hours. We also received comments that some of the public commenters did not feel that all of the stops that were included actually covered all of the relevant area. So we are going to double the number of stops from 10 locations to 20 locations at each of during these odor monitorings in the community. The second, we do feel like there has been a good deal of frustration that was experienced by the community regarding this issue, that they are not being heard, that they do not have all of the information, and then when they have opportunity, they aren't being listened to. And that's a hard thing to try and address immediately, but what we are doing is going to change what was more of a transparency measure of just publicly posting any kind of documents into what it needs to be as more of a web page portal that has all information relative to odor mitigation efforts at this landfill, whether it's coming from South Coast, whether it's coming from a different government agency. And that's going to include notice of where you can call in complaints, whether it's to the landfill itself or submitting a complaint to South Coast. It's going to include notice of any public meeting where odor might be discussed, including how to access that meeting and whether or not public comment will be taken, as well as including all public disclosure of any documents, reports, logs that are created as part of this process or required to be submitted by any government agency. So this will hopefully allow the community to have a place to get up to date and understand where their voice can be more effectively heard, and where their voice will be listened to, and where public comment can be received. And in that same vein, the landfill will start hosting a monthly meeting, whether it is virtual or where possible in person. If it is in person, it will take place directly within the Val Verde community. And it will provide regular updates, both updates on the status of various elements of this order, but also other ongoing efforts of odor mitigation throughout the landfill as required perhaps by other public entities. So that I think does address some of our concerns with ensuring that information is getting to the public. And last, I kind of have a little bit of a catch-all. We wanted to make sure we addressed specific comments and questions that board members and members of the public mentioned. So firstly, I think it was a question from one of our board members about if you are conducting these odor surveillance, are you coming directly from the working face and have odor fatigue? Or we specified now in condition 1C that you cannot have come from the working face prior to conducting one of those surveys. We've also clarified that condition with respect to clarifying that every one of the stops listed is conducted on each one of the surveillances. That was always the intent of the parties. So we did want to clarify that language. We also did clarify the language in condition number 2 that any logs or resolution that are from the landfill's complaint line are going to be submitted to South Coast in condition number 2. Those will also be posted to the public web page that the respondent will submit. That's in condition 16. We also did add to the report and itemization of work for the expert consultant that they will provide an analysis of best management practices at landfills in response to a request from a board member. And we also added to that consultant work looking at future locations that can be sort of these backup areas for active cell locations. As you'll see in these conditions, we are doing that currently for cell 6. And I think as Mr. Jasinski alluded to, this took us a little bit of a Herculean effort to do so over the weekend by the respondent. We don't want that to be a Herculean effort. We want to have that flexibility if we come into this same problem with future cells. We are going to evaluate wind flow patterns at future planned cells. So hopefully we can avoid that. But this does give us a flexibility to have that as sort of a backup, where if we need to divert waste out of an active cell, we will have that information to be able to do that. In response to, I believe it was public comments, there were some concerns as to what kind of odor neutralizer is being applied and how much it is being applied. We added disclosure of the quantities of this to the public webpage alongside any safety data sheets of this neutralizer. We did clarify that this will be an odorless or unscented neutralizer that must be applied. And we also added an assessment by the consultant of odor neutralizer application as part of this best management practices to be able to assess whether or not this is disproportionate or some other efforts might need to be taken. And lastly, in response to both public comments and board member comments regarding health effects, we did include where the respondent is required to conduct studies under the auspices and direction of the County Department of Public Health and monitoring, that those studies will be described as to their status, and any results or reporting from those studies will be included on that webpage, so that members of the public will still be updated as to all of those studies that are being conducted and required under the respondent's permit. Right. So with that, I will end my sharing, and if you have any questions about any of these, we are of course happy to walk through, or of course happy to put on a witness. Thanks. Thank you.
First, I want to just appreciate the fact that the parties did clearly try to attempt to address every single one of the points that was raised by the board and the public, and we very much appreciate that. Mr. Jasinski, did you have anything to add to Ms. Roberts' presentation before we ask questions?
No, I think she covered it all quite well.
And I also appreciate you doing it in that PowerPoint presentation so that members of the public can really understand what was changed, as well as the board members. I have a number of questions with regard to conditions 3 and 4 on pages 6 and 7. I'll tell you some of the nature of these questions, and that way, if we need to bring on a witness, we can do that. I'll just kind of list them out, and that way we can see where we go from there. First of all, I wanted to understand if 50% of the incoming waste is directed to other permitted areas. What areas are those? Because I don't think we were clear in the last hearing, and that was a question that was asked. Where else could the trash go other than in cell 6? So I want to know what that is, and so a follow-up question to that would be if it can accept. If other permitted areas can already accept 50%, can they accept 100% until the other intermediate or the other, I will say, meaty parts of this proposed order are in place, including the fans and the alternative daily cover. The other question I had is on, I hope I have the right, line 5 on page 7, which is also in condition 3, the idea that this 50% diversion would not occur if the wind speeds were less than 1 mile per hour. And the reason I asked that question is because my understanding of Mr. Israel's testimony was the worst complaints and the worst conditions were in stagnant wind conditions. So it seems to me that less than 1 mile per hour is a stagnant wind condition, and why aren't we diverting 50% at that point? So that's maybe a multiple question. I also want to understand how this idea of having the weather underground dictate whether it's 50% or 70%, how that would work and how it's enforceable. Is it that you can that quickly respond on an hourly basis to changes in wind patterns to divert 50% of the working face or the incoming trash to another working face? Are you going to keep records of that so that the district can ensure that, in fact, if less than 50% was diverted, that Weather Underground said that the weather conditions were as they were supposed to be? So I wanted to understand how that is enforced and whether that's really a workable condition. And finally, 70% is the absolute maximum under condition 4 is a little bit higher than the 60% that was originally in the first order between the hours of 9 and 11, I think, in the morning, which was when the majority of complaints came in. And I just wanted to hear why 70% would make sense as opposed to 60% during those hours. And so those are the nature of my questions with regard to those conditions. And I don't know how we would address that.
Thank you, Madam Chair, for those questions. I think some of them can be directed to respondent's witness and perhaps some of them to the district's witness. If I could start with a brief clarification regarding the question of the Weather Underground question and how that would be enforced and whether it's enforceable. I do want to note that this condition is structured such that it will also be premised on actual real-time monitors that are currently in place at the landfill.
Okay.
And that's included, I believe, in line 7 of page 7. And so the understanding of that was that if real-time monitors show that there are those adverse wind conditions, that would automatically trigger it. The reason that the Weather Underground or similar prediction site was included is that actually might precede the actual conditions showing up because they are prediction websites rather than just a monitor. And so the idea is that actually might allow them to change sooner in advance to actually prevent an odor complaint versus responding to conditions based on their real-time monitor.
And as that monitor, those wind projections, I don't recall if that's in another condition, is that information that will be made available to the district?
I don't believe currently that their wind monitors are being made available to the district. I can discuss with council whether they would be opposed to that, but I would say that a lot of their wind monitoring data, which is recorded, does go into the assessment that their expert consultant would be relying on as part of his reporting. So it is being monitored and collected as far as data. But certainly, if that's something that the chair would like, we can discuss having that being reported to the district as well.
Okay, and thank you for clarifying that it's also based on that. But I would like to see that. And then I would like to know how quickly the landfill can respond. to that data and make the changes as are necessary to go from 50% to 70%.
So the condition does require monitoring on an hourly basis of those monitors.
Mm-hmm. It's the response time, I'm wondering. So I think that's more of a process question for the landfill. And also for the landfill, I wanted to understand why, what are those other areas that the 50% would be diverted to, or the 30% would be diverted to, and why can't all of it be diverted in the short term?
Yes, Madam Chair, I think I can address the remainder of your questions. If you happen to be unsatisfied, I can bring Steve in. He can probably explain better than I could. But with regards to the other areas, these are actually old cells in the northern portion and northeastern portion of the landfill. And so these are areas where there may have been some settling. They were otherwise closed. What the landfill did was have their consultants inspect whether there was available airspace within these locations where potentially waste could be diverted to. And now these locations generally, and why we hadn't looked at them previously, are used for other things at the landfill, whether it might be a wet weather tipping pad, or maybe there's some type of material diversion or a roadway that's getting used in some of these areas. It takes a commitment of some resources, and it's really backward looking in a way that the landfill isn't really used to. And so that also kind of gets into why the 50% measure and not 100% measure makes sense, because we also want to be forward looking in how we craft this. If we were to do 100% to any of these areas in the immediate term, we wouldn't be taking advantage of what we believe to be favorable conditions right now, typically anyway, with regards to wind conditions. It's operationally somewhat of a prerogative for the landfill to get cell 6 built up so that it can then move to as I believe Steve testified last time, move into cell 8. And cell 6 needs to be built up in order to support the back end of cell 8. If you can imagine a bridge like this between the two cells, cell 6 would have to get built up in order to support it. And so the percentages that you see in there for the differences are both for what can be done in the immediate term, and it's also looking longer term. What will Chiquita be doing, after any types of orchard fans are implemented or enviro cover is implemented, so that it has a dependable process that it can implement for as long as the order is in effect. And so that explains some of those percentages. Now, as to the turnaround time, I think Ms. Roberts was correct when she stated, that's why we have the projection issue in there. The site regularly monitors sites like Weather Underground, the Weather Channel, and others, so that it can manage operations when it can see where the winds are blowing. My understanding from the site is that it can make that turnaround within an hour. And so I think it's the last sentence in condition number 3 that you'll see that says, if at any time those winds are projected to start blowing towards the Val Verde community between 1 and 5 miles an hour, the landfill will essentially start turning around its operation so that it can fit within the parameters of that condition.
Okay, thank you. That covers almost everything. The only remaining issue that I have, aside from making that wind data available, and you can discuss that and get back to us at an appropriate time. But the other question I had is during stagnant wind conditions, and isn't it correct that the testimony that we heard at the last hearing was that it is stagnant wind conditions that cause odors to be in that community from cell 6. And so having that exception to the 50% for winds of a speed less than 1 mile per hour seems counterintuitive.
So, Madam Chair, that was in response to Mr. Israel's testimony, And the idea of stagnant is that it does need to be some movement of air to get out of the actual canyon where waste is accepted. But that lower speed, and we capped it at about 5 miles per hour, is what prevents it from moving out of the valley, which the valley of Valverde, where the community resides. So we think that actually fully captured the stagnant conditions, where it's blowing just enough to cause odor complaints, but not enough to actually move them on and disperse them.
Okay, and that's based on all the data that Mr. Israel and the landfill have collected and assessed. Is that correct?
Yes, that's based on Mr. Israel's testimony. He does when he and any South Coast inspector, when they go out to investigate a complaint, they actually take wind speeds while they're investigating. And his testimony is when you get really stronger winds, that actually stops most complaints because it blows them out of the community faster. And when you have lesser winds, that's when those complaints linger and are most likely to come in.
Thank you. Very well explained. Board members, that's all of my questions on the changes amendments. Ms. Verdugo Peralta has questions.
Thank you, Madam Chair. First of all, I want to address the emails that were coming from UCLA. Where I don't think that it's relevant is because of the fact in the second sentence it says, so it is not specific to or targeted to the Castaic Valverde area. However, it is possible each year that we do have some respondents from that area. So to me, this is not encompassing and does not address that specific area. They may be only talking to a few, but in general, this sounds like it's a larger region. While I'm looking at the last bullet that we discussed, that the Department of Public Health would be conducting those health studies, that's where I'm feeling that we're covering this more. And my question is, will this be specific to this area surrounding that landfill? And will there be a report that is issued, and will the AQMD get a copy of that report, as well as it being public to the residents there? And how long is this health study going to take? Those are my questions regarding that.
Yeah, if I could briefly respond, and starting with that email, that email was the district investigating in response to, I believe it was a public commenter who specifically cited this particular study. And again, district was just not familiar with it at that last hearing. So we did want to be able to provide information. Based on that information provided, we don't think it's relevant to this particular matter before the board. With respect, we did want to address the idea of health studies, but where those come from is actually not under the direct authority of the South Coast AQMD, and they are actually included as conditions in the facility's conditional use permit that is issued by Los Angeles County. And so when we put those into the proposed findings, that they will be included publicly. So they are not directly submitted to South Coast AQMD unless that is required by the facility's conditional use permit. And those studies are not directed by South Coast. That is outside of the district's direct authority. But they are going to be included into this public web page to be accessed by the public as part of this order. But the actual studies themselves are going to be controlled by the respondent's conditional use permit.
Well, I'm glad that they're going to be occurring nonetheless. My other question had to do with the meetings that are going to be conducted monthly. Will there be a representative from AQMD attending those meetings?
There certainly can be. And for the immediate short term, almost certainly, yes. And as those meetings evolve, it will potentially change as to what staff member, whether that is legal counsel whether it is a member of our engineering team, a member of our compliance team, as appropriate based on the specific topics of those.
Okay. And while we're on the subject of the residents and how this is affecting them, I think you heard me mention the fact in regards to their property, and I don't see it addressed here, but I went back, and bear with me here, I went back to the Health and Safety Code under 41700, prohibited discharges, and if I may, I would like to read that. It's because it's all one sentence. It says, except as otherwise provided in section 41705, a person shall not discharge from any source whatsoever quantities of air contaminants or other material that cause injury, detriment, nuisance, or annoyance to any considerable number of persons or to the public, or that endanger the comfort, repose, health, or safety of any of those persons or the public, or that cause or have a natural tendency to cause injury or damage to businesses or property. That's actually there. And we were having the discussion at the last meeting that consideration for property value was not going to be addressed. I really do think that we do need to address it, because it is affecting this community detrimentally, not only in, as was mentioned by one of the witnesses, that their testimony that they could not refinance their home. Or another one was mentioning about how it's difficult if they are going to try to sell their property because the valuation is being affected by the landfill. So if I'm looking at this, and this is part of this particular issue, and it's actually in the Health and Safety Code, then I think that we do need to address that. And one other thing that I wanted to say is that I'm looking at this holistically. This is, to me, an environmental justice issue. The federal government, through EPA, their definition of environmental justice is that everybody has the right to clean air, clean water, and the soil not be contaminated. And that doesn't mean just in a low-income area or just in a community of color. That's everybody. Everybody has the right to that. And I think that this is affecting them detrimentally to the point that it is also an environmental justice problem. So with that, I really want to ensure that we're addressing the concerns of that community. And if we're not including their concerns for the property, I think we are dropping the ball.
And I think well stated. And I ask if you have questions or thoughts about what else you would want to be seeing in the proposed order. And I think Mr. Ali also wanted to be heard.
Madam Chair, may I briefly respond?
May I finish? As I'm addressing your question, Julie, I would like to see a report. I would like to see a report of what the valuation has been within, let's say, at least a 5-year period, benchmark, and then what has happened since then. Has it stayed the same? Has it gone down? What has been the effect? And did it occur, as was mentioned before, when that one working face was changed? Because these people they're suffering, and how do we address that? So I'd like to see a study of some sort.
And I will let Ms. Roberts address that. I do want to just mention for the record that I'm very glad you read the definition of 41700. However, again, I just want to, for the record, since we are addressing a stipulated order for abatement, we do not need, the district does not need to prove, and we do not need to find a violation. But that's a different matter. I just wanted to make sure that's on the record. And Ms. Roberts, if you can address that, and then I think Mr. Ali wanted to add.
I also have a point to make, Madam Chair, after Roberts, if I could.
Thank you, Ms. Verdugo-Peralta, for that point. And if you don't mind, I'm actually going to share my screen because I think this is important. What I'm going to show you is, this is the text of Rule 402, just because I know there are members of the public. And Ms. Verdugo-Peralta, you read from section 41-700. I do want to clarify that Rule 402 from the district is identical in the operative language, in terms of, does include that same language in terms of property damage. And so what I want to respond firstly is the district does interpret this as a causal link, because of that, that last sentence. In looking at injury or damage to business or property, it is the nuisance or discharge of air contaminants that cause injury or damage to business or property. So there is a causal element to making that finding with respect to property or business loss. And so while we do acknowledge that that is absolutely included in the language, both in the health and safety code and in the district's rule regarding nuisance, we do want to emphasize that idea of cause because it is such a high bar. It is not easy necessarily to show cause. And the idea that property loss may be affected by more than one variable, including other variables that are really not necessarily relevant to the hearing board's jurisdiction of addressing a nuisance. That said, the district does hear your concerns with respect to property value, and we are willing to take that back and look at that, but we do have to stay within the constraints of what the district's jurisdiction actually is with respect to the question of property loss. And it does require for the district to be able to show a violation of either of this rule or that health and safety code section based on property loss is a very high bar that requires a substantial amount of evidence to show that the loss is actually caused not only by the landfill's presence, but by the landfill's issuance of air contaminants that's causing a nuisance.
Well, I understand what you are saying, Ms. Roberts. I believe it's incumbent upon us to look at it and in transparency to the public, whether it's a high bar, low bar, medium bar, I don't care. I think we ought to look at it for the sake of the public. And
I'm sorry.
I was just going to mention the fact that this is detrimentally affecting those residents. While I understand that there are many variables that could enter into this, as far as what the valuation of their property is. The other thing I had mentioned before was disclosure.
Can I just stop you right there?
May I just finish my sentence? I don't have much longer.
Okay, but it's 1 o'clock. I need to go on a pre-hearing conference. That's the reason why.
Okay, so do we want to continue this discussion then when you come back?
I don't want to cut this conversation at all. And I know Mr. Dujinski wants to be heard. I know you still have more to say, Ms. Verdugo-Peralta, and Mr. Ali also wants to be heard on this topic, and maybe other members, I don't know. So we will pick up, and I apologize, Ms. Verdugo-Peralta, with your last statement, then we will go to Mr. Dujinski and then to Mr. Ali. And I'm going to say, let's give it a half an hour because this particular pre-hearing has the tendency to go longer, but I will continue it if it goes any longer because this matter needs to be finished today. So 2:30, we will be back on the record. Please try not to leave the hearing. If you get tossed out, come back in and definitely mute your microphones. And we will be back on the record at 2:30. Thank you. Just as an update, the pre-hearing conference just ended. Thank you all for being so patient. And I'm just going to give the clerk a few minutes to, that was on teleconference. She needs to come back and get back on Zoom. And I would also like just to take one moment. So we'll be back on the record in just a few minutes. Thank you for your continuing patience. And Madam Clerk is back. Thank you so much for juggling. Okay, I see, waiting for Dr. Bernstein to come. There he is. And I think we are all back. Is that correct? Okay, then we're going to go back on the record. And before we left, Ms. Verdugo Peralta, I so rudely had to interrupt her.
Madam Chair?
Yes.
Never mind. I see him. He's back. Thank you.
Okay, yeah.
Okay. Okay. Sorry, I just need to move my folders and files. Ms. Verdugo Peralta, you may continue where you left off.
Thank you, Madam Chair. I just want to recap what I had said is basically that I believe that we should look at the property value that may have gone down and it may not have. We don't know that for sure, but it is affecting these people from what they are telling us detrimentally. And I don't see the harm in taking a look at it, a snapshot, if you will, just like when you're looking at stock and you see what the history has been, let's say in the last 5 years, up or down. That's what I'm looking for here, to be able to turn around and tell them, yes, you're correct, or no, you're not. And if it's part of our health and safety code, then I think that we should do it. It's as simple as that.
Before I turn to Mr. Dujinski, did you have a specific, I do understand the sentiment, and I understand that that's very important, impact to the community. And you heard what Ms. Roberts said about causation. And again, just going back to the fact that causation is a tricky thing, but more than that, we do not need to make that bridge because this is not a contested order where we need to. So what is there did you have a proposal you'd like the parties to consider that would be within their ability or jurisdiction to do?
I don't think it would be very difficult, nor do I believe that it would be time consuming for us to, or somebody on the staff to just look at the history of property value in that area. How long ago did they say that face was opened, that working face?
I think it was in
April of 2020.
Thank you.
Okay, April of this year. Okay, I think that a 5-year history would be more than sufficient to take a look at the property value and just plug in those numbers and put it on a chart. That's it, to be able to look at it.
And Ms. Verdugo Peralta, we haven't discussed this at great length previously, and we haven't offered it to the board into evidence, but I would proffer the contents of the environmental impact report that was prepared for the Chiquita Canyon landfill in 2017. This is a document that was adopted by Los Angeles County when it approved the continued operation of the landfill. It's within the county records. The hearing board can take official notice of this document under Hearing Board Rule 9E. And there are several salient conclusions which kind of touch upon every one of the points that you brought up in your comments. And I just want you to know that we're hearing these, and these are things that have been analyzed. And so with regard specifically to housing property values, when the EIR was approved, they conducted an analysis of housing property within the Val Verde area. And that analysis specifically concluded that there was no basis to conclude that the landfill has impacted surrounding property values. In regards to public health and some of the other concerns, those analyses are similar. There was a public health analysis that was prepared that was a part of the EIR. There it concluded that, we heard some public testimony about asthma rates. It stated specifically that the prevalence of asthma in communities around Chiquita is indistinguishable from asthma prevalence elsewhere. The same for cancer mortality rates and things like other types of potential issues. And so these things have been comprehensively analyzed in other locations. And, I think we kind of lose sight of the scope of these proceedings when we forget that we're actually not trying to prove any type of violation or disprove any type of violation. The parties have come here to the board in an effort to avoid needing to go through that process, because this would be a step to abate. And that's the name of the type of order we're looking for. And so I think that, at least speaking for Chiquita, and I think I can speak for the district, we think that the order we presently have does that. But if the board would like to look into the document that I'm speaking of, I'd be happy to share it with you all. I can send it to the clerk. Otherwise, the Los Angeles County Department of Regional Planning, on their website, it's directly available there. And it discusses potential public health impacts. It discusses property and other types of values. It discusses things like environmental justice, and it covers quite comprehensively potential impacts from continued operation of the landfill. And so if the board would be willing to take that into evidence, I would submit it.
I'd like to see it.
Okay. I can send that to the clerk.
Once we have an opportunity, we can have it made available to the board members. And then we could, at some point, since the clerk's office is so overloaded, please make it available to the public. But yes, we'd like to have that, and we could mark it. So how can we go about doing that, Mr. Duchinsky?
I could email it to the clerk, and if she could circulate it around. It's a large document, so I'm not sure if you guys have any types of restrictions on how large the emails can be when they transfer around, but we could set up a document share site as well, if that's helpful.
Is there a way to isolate those specific subjects from the EIR?
Yes, we can. And actually, I have a letter prepared for this. I'll send it to the clerk right now. And if it tends to answer your questions, that would be good. If you want more, we can circulate a link to the EIR as well.
I would like to see those subjects isolated in addition to a summary, if there's a summary.
Yeah, absolutely.
And so let's do that. Let's have that circulated, and it can be introduced at the appropriate time once we have it. I just want to point out that it is, as Mr. Duchinsky said, a 2017 EIR, and the current issues before the board are in 2020. And so things could have changed from there. However, as I think Ms. Roberts and Mr. Dudzinski and I have been saying, while I think it's important to have that information if we have it, the board is not tasked currently with finding a violation. But again, we've been hearing a lot of testimony with regard to impact, and that we do need to hear that in order to best craft or have the parties best craft an order that will have some real impact. So I'm not saying it's irrelevant.
The only other thing I just wanted to say is I do appreciate the fact that our district council and Mr. Dudzinski have worked to get what they have so far. I'm just asking for a little bit more. Thank you.
Thank you. And I very much, and I know Mr. Ali wanted to talk next, and I think he also very much appreciated the comments and how you stated it. Mr. Ali.
Actually, I'll just reserve my comments to after the public has had an opportunity to provide testimony.
Okay. Did you have any questions on any part of the revised proposed findings?
Yes, actually, I do, and I'm glad you brought that point up. First, I'd like to thank Ms. Verdugo Peralta for her comments, and I do want to associate myself with everything that she stated. To Ms. Roberts, thank you for the work that you, as well as, well, both sides, thank both sides. But Ms. Roberts, I wanted to, on behalf of the senator, I wanted to posit a point last week, and he actually asked for the health study to be included. And I just wanted you to reiterate at some point, just for the public's edification, he did ask for it and you did provide that. And so we'll work in concert with Los Angeles County with respect to that. AQMD doesn't have the jurisdiction over that, but you stated you contacted, just kind of clarify, you contacted the County Department of Health and you work in unison within that vein. Thank you.
Thank you. To clarify, yes. So what we contacted, and the email is included, I believe it was Exhibit 4. What we contacted is actually UCLA, and they actually conduct a statewide, I believe it's called the California Health Interview Survey, and they conduct this annually. And this particular survey conducted by UCLA was actually brought up in public testimony and in discussion with various board members. And this was the study that the district was just simply not familiar with at the time. And we did commit that we would look into this study if it had relevance, particularly because a member of the public did mention that they were a part of it. What we received in terms of information, which you have included, is all of the information that we received, but because it is a statewide health survey, it is not particularly focused on this area, although they do have a kind of randomization of how it gets sent out. So members of this community might receive that survey from time to time. So I do want to separate that from the other aspect of health studies that are being done under the auspices of the facility's conditional use permit. That's the permit that is issued by Los Angeles County, and it is referenced in the proposed findings and conditions that these will be included as things that are put out on this public webpage that is being created as part of this order, because we do think it is important that that study is made public and put in an area that is readily accessed by members of the public who maybe do have concerns about health regarding this landfill. That conditional use permit specified both the parameters and how that study and monitoring would be conducted. And that permit, because it is not issued by South Coast AQMD, we don't actually direct the extent of that study, but we did want to loop the idea of the report into what will be publicly available on this webpage that's created as part of our order. And I hope that kind of clarifies and answers your questions.
Yes, Mr. Ali, did you have any other questions? Okay, thank you. Board members, additional questions on the revised proposed findings? Mr. Balagopalan, is that? You are muted.
Yes, yes, thank you. Now, I also want to echo the sentiments that the board members have expressed in appreciation for the revised order. I think it incorporated a lot of the discussions that was held at the last hearing, and I think it's a much better living document. And as Ms. Roberts said, this is the first step framework, basically. So I think that that's a good step towards getting the facility and the community into facilitating to some compliance and creating less orders in the community. I do have a few questions, Ms. Roberts. I know the last time you showed a map with the 10 stops. If you do you have the updated with the other, you added 10 more stops.
I don't have that prepared in advance, but if that is something that would be necessary, I can have staff work on that pretty readily, I believe.
No, if you don't have it, that's okay. I was just wondering how they were distributed.
Yeah. I apologize.
Okay, that's fine. The other question I had, I know there was a number of references made to the conditional use permit in specific condition. Is that something that's also available on the website that Chiquita Canyon is going to put up, or on the public side, or do we have to go to the Department of Public Works to get that?
It is publicly available on the Department of Public Works or the Department of Regional Planning, I should say, website, but I would not object to including it specifically as part of the things listed on as part of Condition 16.
Yeah, especially because there were a number of very specific reference to it in the order.
I wouldn't oppose to. I think it could be added to. I believe it's Condition 16F. That posting of their conditional use permit could be added to that section, which refers to reports and orders, and possibly can add that to include permits.
Okay.
Mr. Dudzinski, do you agree to add that?
Sorry, I was on mute. Yeah, it'd be fine to add the conditional use permit.
The last question I had, and I wanted some clarification. I know the fans that then the misting that will occur, it didn't say what triggers it, how long it's on, what triggers the operation of the fan and the stopping of the fan. So that wasn't very clear in the order.
From our standpoint, and I will defer a lot of this to the Respondents Council, but based on Mr. Casulo's testimony on behalf of the respondent, that is kind of an iterative process throughout the day based on the amount of trash that's received. So it wasn't something that we specifically put a condition of when and how that could be changed.
And I would just add that, in appropriate times, I believe the site operates those fans near continuously, and really is modifying them and changing the way it's using them on a minute by minute or hour by hour basis. And so I don't think a trigger would be necessary because Chiquita is concerned with reducing any potential odors, but we could potentially discuss that.
Okay, it's not very clear that there has to be some situation when that needs to be started up and the misting occurs. So I think a little more clarity is saying if it's left open-ended, you could you probably don't need to run it when at nighttime, or I don't know if they do that or not, because the covers have not been pulled back and there's no active work going on at that time. So just is that it's not 24/7. I take it you said as needed. What triggers the need? Is that wind speed? Is that the odor level is higher at a certain point? What triggers the fan to be and the misting? And I'm not a big fan, I myself say, of the fan and the misting. And I hope the underlying odor source is addressed, and the fans is a temporary measure that go away. But nevertheless, I just wondered, if there's some clarity or some criteria, basically, even if very general, when that will be operated.
Can you remind us, Mr. Balagopalan, which number condition that is?
Yes. Yeah, if you look at number 8,
Thank you.
the revised, yeah, number 8, yeah. Says the respondent shall use fan with an unsided odor that is prepared, shall be pumped into the nozzle to deal with the odor around the fan face for dispersion, but it doesn't quite say, what,
okay.
when will that, what triggers it to be operated?
So we'll add that to for the parties to discuss if there is a trigger, and should we, is it something that had been discussed between the parties previously? No, Mr. Dudzinski shaking his head. Okay, so we'll put that aside. We will take a break at some point for all of these questions to be addressed. Did you have anything else, Mr. Balagopalan? Because I see that Ms. Verdugo-Peralta has her hand
No,
raised.
I don't. Thank you.
Ms. Verdugo-Peralta.
Thank you, Madam Chair. One more thing, I'm remembering the discussion at the last meeting that Mr. Balagopalan mentioned the fact about best practices. And was that included, that we would be looking at best practices? Because I don't see it.
Yes, it has been. I think it's 18I or something.
It was added to the.
Okay, I missed that. All right.
I believe.
That I had, I wanted to make sure that that was included because I thought that was a very good suggestion. And also, I know we're not supposed to be actually, this is a whole separate issue than any other landfill, but going along the best practices and what has occurred, I believe that there was an issue with Sunshine, that the fact that they put soil on top and it had an adverse effect. There was a mention today of putting a natural substance on top. And I just want to make sure that that doesn't occur again. Do you know what I'm talking about?
For the parties, it was very thick soil cover that was not peeled back at the beginning of each day. And I don't believe that is either in use at the landfill or proposed to be in use under these conditions. Is that correct, Mr. Dudzinski?
That's correct.
Just wanted to make sure on that. Thank you.
Facilities using tarps, and there's a provision within the current order for use of an enviro cover or enviro cover type material.
And just to refresh our recollection, the benefit of the enviro cover is that it does not get peeled back. Is that correct?
That's correct.
And trash just goes on top of it. So whatever amount of the landfill you're using, it's almost like it's uncovering at that amount at that pace. Is that correct? Any other questions by the board with regard to either what is proposed, what you had hoped would be proposed, or just any other questions? Okay, great. I had mentioned earlier that if you are a member of the public and you wish to be heard, if you could raise your hand if you are on Zoom using the virtual hand raise function that will come up if you're on a PC and you move your mouse, you'll see it at the bottom. If you're on a phone or a tablet, I see one person has raised their hand. Thank you. 2 people have raised their hands. Okay. Anyone else, just go ahead and use that raise hand function. And again, if you could, if you are a member of the public who has not yet spoken on this matter, then please address the board in any testimony you wish to give, including your experiences firsthand, etc. If you have spoken before the board, that doesn't mean you can't speak today, but if you can please confine your comments to those you have not yet given with regard to any of the proposed changes that we're considering today. We would appreciate it. And I want to make sure that Paul, are you on and are you running the clock? I see it's up. I want to make sure Paul
If
is.
not, I can run the timer on my watch. I'm in my phone, so
I'd much prefer to,
yes.
if possible. Is Paul available? Let me see if Paul sent me a text. Timer needed. Yes, the timer is needed. Oh, that was from Faydu, Paul. Okay. All right. If we don't, then I'm gonna just give a couple more minutes for anybody to raise their hand. So far we have, and I'll take them in this order, Lucy Frazier and Susie Evans. And so I can do it on my phone as well. Okay, I'm going to start with 3 minutes, but once I introduce the person.
No, it's on. Yeah.
Okay, so if you can unmute Miss. Oh, first of all, well, if you can. First, those who wish to testify, I don't know if you took the oath. So I'm just going to administer really quickly. So those who wish to testify, I see so far Lucy Fraser and Susie Evans. If you can please raise your right hand. We don't have to see you, but do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God? Just indicate. And then I'm going to call Miss Lucy Fraser, and if you can unmute her line. She was a panelist. Yes, and if you can, before we start the timer, if you can just state and spell your name for the record and just let us know that you did take the oath.
Hi, yes, my name is Lucy Fraser, Lucyfraser. I did take the oath, and I have more so of a comment for the board. I was online and I didn't see the revised order or the redlined order available on the documents, and so I was wondering if that would be available today.
I thought I did see it, and in fact, I was able to pull it up. Let me, while we're speaking, see if I can do that again, and perhaps I just didn't give correct. Okay, let me see. I'm on AQMD.gov. Okay, and if I go to the top under About, and I look for Hearing Board, I pull up the Hearing Board site, and then along the left-hand side, we'll see Help and Instructions, Board Members, et cetera, Hearing Board Case Documents. Okay, and then the fourth matter down under Case Documents, you'll see the first one is Petitioner Exhibit, and I believe that would be the exhibit, the email that we were talking about between UCLA. The second document on there is redline version of revised proposed findings and decision. That is the red line version, and next to that is the revised proposed findings and decision, and it's the clean version. So hopefully you'll be able to get that now. Here, I'm going to put up again those directions. Oh, I can't share my screen because it's already been shared. But Ms. Fraser, did you attempt to find it again?
I have, and I've tried to do it during this call, but it's only showing the proposed order from December 3rd. It's not showing me the most recent revised version.
Okay, and right now I'm going to press on it again. Maybe you need to refresh your browser.
Because I did it as you were speaking, Ms. Pruzak, and I was able to see it. So
me too. So if any member of the public is having difficulty, just go ahead and please refresh your browser. Maybe go off your device and come back on. But it is there, and members of the board have been able to pull it up, and so it is there. Did you, based on the presentation today, would you like to make comments?
I have no comments to make. Thank you so much.
Thank you, Ms. Fraser. We appreciate your time today. Okay, and now I'm going to call on Susie Evans, and if we can allow Ms. Evans to talk. She's under attendees.
And Madam Chair, 3 minutes?
Yes, but first I'm going to take Ms. Evans's full name, spelling, and indicate whether she took the oath today.
No problem.
Should I allow her to talk? Is that?
Either way.
Okay, let me try. I can't unmute her phone. Can you do that, Paul, or does she need to do that?
I think I just did it.
I just did too. Go two-way thing, yeah. She's
okay, Miss Evans, can you spell your name for the record, please?
Officially, my name is Susan, S-U-S-A-N. Last name Evans, E-V-A-N-S. And I did speak last week, and I appreciate the opportunity to speak again today.
And you took the oath today?
Yes.
Okay, Paul, you may start the clock then. Thank you. Go ahead, Ms. Evans.
Thank you. A lot of the people in this area have not been able to sit here all day like I have. We look at the amended revised division of what it is. And it's, again, it is a fox watching the hen house. I don't see where anybody is doing anything to punish them for what they have done to us, whether it be smells or whatever. Under the old CUP, they took in Rocketdyne, Malibu carcinogenics, and Santa Paula explosives, toxic stuff where firemen couldn't have it work since and equipment was declassified. I want to be sure that with what you're doing now, there is somebody who is going to make them adhere to what they agree to and pay the price of not adhering to it. I mean, I'm one of the few that is probably on here because everybody else couldn't be. But that's how I feel right now. It's the fox watching the hen house.
Do you have anything else to add, Ms. Evans?
Not really. That's pretty much the feeling of the whole town. I mean, we've all discussed this since last week, and we've all kind of said everything that has happened over the last 20 some years has been the fox watching the hen house, and LA County has stood by, and AQMD is doing the best they can, but LA County is not doing anything to stop them from taking illegal stuff and from doing whatever the heck they want.
Thank you, Ms. Evans. Before I turn it over to see if there are any questions, I just wanted to, first of all, express our appreciation for you showing up both last week and today and representing your community. I hope that it is clear that the board members and the parties, given that they have attempted to address all the comments that were made last week in the revision, that we are taking your comments very seriously and appreciate them very much. We also recognize, for the record, that unfortunately, as the hearing is during the work day, even though it's remote, that a lot of people will not be able to be present and give their testimony. And we appreciate your saying that for the record, and that you have spoken with other members of the community. I wanted to just address holding the petition, the respondent to it, Chiquita Landfill, to the revised order. While we're not addressing things that are outside of our purview, this order is binding on, even though it's a stipulated order, even though we do not need to make a finding of a violation. It is an order which is enforceable, just like any rule of the district. And so the district will enforce anything that is not followed by a respondent, and they will be held legally to this stipulated order. And again, stipulated just means it falls within a different category. And we have to make different findings. And it just means that Chiquita Canyon is in agreement that it will, that it wants to be in compliance, but it's still an order. And this hearing board can enforce it as well. Well, we're not the enforcement mechanism, but if the district comes before us later on, and there is a status that is being, right now it's proposed to be in March, the next status and modification hearing, and I'll make that clear during this hearing. And so this board will continue to be on top of the status, and so to make sure that it's being enforced properly. And with that, let me turn it over to Mr. Dudzinski, Ms. Roberts first, if you have any questions.
I have no questions, but thank you very much for your testimony, Ms. Evans.
Thank you.
Mr. Dudzinski, any questions?
I have no questions. Thank you.
Board members, any questions for Ms. Evans?
I did have a question. Ms. Evans, I know since the last time you spoke, have you encountered odor episodes since the last hearing?
No, I have not. I did notice that things are moving from my side of the dump somewhere else. I don't see the tippers on the ridge anymore, and the ridge is higher than, or should say, the top of the dump is higher than the ridge line.
And you're along Lincoln, if I remember correctly, you were saying last time.
Yes.
Okay. All right. Thank you.
Thank you.
Board members, any other questions for Ms. Evans? Okay. Ms. Evans, just thank you once again for taking the time to represent your community today for the hearing board.
Thank you.
Okay, and I'm just going to turn to see if there's anyone else who wishes to be heard. Please raise your hand if you haven't already. Okay, and I don't see anyone else. And that, again, for the record and for those who are watching on the webcast, either later or now, that's not to say that members of the community don't wish to be heard on this, just that no one else is present to be heard. I did have one other question, which I forgot until I was discussing the enforcement of this order with the last, with Ms. Evans. And that is, would the parties be willing to consider a quicker comeback date? So the comeback date that you have of March 11th, I realize that you did change it from the Monday to a date when we actually do have hearings, to a date 2 months from now in mid-February, so that we could assess, we could have some means on a quicker basis of assessing how some of these interim measures are affecting the community and the number of complaints, etc. So I'm going to throw that out there, and I'm going to remind the parties of all of the issues that remain outstanding, and then I think we'll take a few minutes off the record for the parties to talk with staff, with their own staff, and then perhaps to talk with each other if time permits. Hopefully I'll get them all, and if I don't, please let me know. I'm sorry, let me change my view. There we go. Okay. First, there was the matter of on condition 3 that is proposed with regard to the wind monitoring real-time wind conditions, whether we could add to that condition to keep those records and make them available upon request by the district, so that that can be monitored. And along with that, also keeping records of the percentage of the working face that at various times and dates, whether it's 50% at cell 6 or 70% of cell 6, so that they can be coincided with that wind data. Also, there was, Mr. Balagopalan requested that in condition 8, if there could be some trigger that is agreed to when the fans are used, or something a little more concrete, if possible. Also, I can't recall if it was Mr. Balagopalan or Ms. Verdugo Peralta, the request to add Romanet 5 to 16F on page 11, which is to add to that which is on the website, the CUP.
Yeah, that was me. Yes.
And I think that was agreed to, but maybe if we could have some language for that. And then I think finally, the only other one I had on my list was the date for the return. And also it needs to be status hearing and modification. That's what we would notice. And that will give the board the opportunity to modify if any evidence presented supports a modification at that time. And finally, did we receive the portions of the EIR that Mr. Dujinski was going to send around?
Madam Chair, the front desk did send to the board members that document, and it has been sent so that it can be put on the website that you so that the public will have access as well.
Thank you very much. So I think unless there's anything else that I'm missing or there was anything else anyone wanted to raise, we could take a break, have the parties look into that while the board looks at the EIR that was sent to us. Anything else before we do that? Okay. So then let's go off the record until 3:30, please, and come back promptly at 3:30 so we can try to wrap up today by 4 o'clock. Thank you. We're off the record. Okay, it is 3:30 and hopefully we can reconvene. I see members of the board are back and the clerk is back, and just want to make sure that we get the parties back. Oh, Ms. Farquhar.
Hi, yeah, we are still discussing on a phone call, and can we just have a few more minutes?
Yes,
Okay, thank you so much.
we will stand by.
Thank you.
Looks like the clerk of the board had sent the documents for tomorrow's cases.
That actually, this is a great time for me to say that. Thank you, Mr. Balagopalan, because let's make use of this time. I don't, Mr. Ali, you're not in, are you in tomorrow for the senator? You are?
I'm not for sure. I believe I might, but I'm not for certain.
Okay, then it's for all of us, including you. We have received several documents for both matters. Ralph's, we received the minute order and the findings and decision from the last hearing. And we also received a timely, it was timely submitted on December 4th. It is the feasibility study that was required in the findings and decision. You will have received it yesterday, I think. Yesterday or today. So those 3 items were sent around for Ralph's. For what's the other matter?
The Orange County Waste Recycling.
Thank you.
Bowman landfill. Yeah.
We just received the minute order from the interim variance for that, and tomorrow's is the regular variance. And Mr. Ali, if you weren't present, then you'd have to do a lot of catch up on the last hearing for Ralph's and also for the interim variance for OC Waste and Recycling, because we will incorporate the testimony into the hearing tomorrow.
Got to burn the midnight oil.
It's a lot. You could also, if you cannot, it's up to you. If you find that you can't be prepared for both, just choose one to be prepared for, and we'll just go with 4 if the senator is not available. You can only do what you can do. I see Ms. Roberts is, I'm Mr. Jaczynski. Excellent. Okay, then we're going to go back on the record. First of all, I just want to take care of the EIR excerpts that were submitted and circulated by respondent through Mr. Jaczynski. And let's mark it first. I'm going to mark the EIR portions that we received. We can mark it along with the request to take official notice all together as exhibit number 5. And I want to respond to the request for official notice, and that request is under 9E of our rules and procedures. And I will say that the decision will be to take official notice of the EIR and for the fact that it was prepared and those decisions and conclusions were made by the County of LA in February 2017, And I equally want to be clear what we are not going to take official notice of, and that is of the veracity of the conclusions made, and also of the fact that those conclusions may be different in 2020. So I just want to be very clear. So official notice allows us to simply take notice of those things which are really just straightforward and beyond dispute, which is that the EIR was done and that LA County reached those conclusions. And with that, I think we will turn to the parties to address the outstanding questions and issues that were outlined before the break. I don't know who would like to begin, Ms. Roberts or Mr. Jasinski.
Madam Chair?
Yes.
You numbered this as petitioners number 5?
Oh, I'm sorry. A. A for respondent. Thank you for that clarification. So this will not be the EIR portions, and the letter will not be number 5. It is A as in apple. Thank you for that clarification. Okay, Ms. Roberts or Mr. Jasinski, who would like to begin?
I think Ms. Roberts took the laboring or explaining all of our changes this morning, so I'll try and take this one, equal division of labor. And so on, I think the first and second issues are kind of part and parcel of the same issue, and it's related to the record keeping with regards to the wind data, either the projections or on the ground, as well as the size of the working face. I think the parties agree that some record makes sense there. You know, Chiquita is going to be monitoring wind on an hourly basis during the operating day. We can, of course, pull those records and include that in a log. We would also propose that the working face size gets monitored either, you know, on a day when Chiquita has full build out. So if we're at the 70% of cell 6, it would be the end of the day. Chiquita changes its working face size in response to environmental conditions or detection of odors. It would record the changes in the working face based on that.
And do you have language that you'd like to suggest for that?
I don't. Probably have to think about what that would look like. I think it would be, you know, Chiquita respondent, excuse me, shall submit wind monitoring and wind observation records, as well as a log of working face conditions. Based upon the size of the working face during the operating day, comma, specifically any changes that are made in response to odor complaints or in response to wind conditions. And I think that's it. Correct me if I've missed a portion of that.
I think there was also an agreement that those records would be made available to the district on request. And the district would submit that those could be sent to Mr. Larry Israel in accordance, and his contact is included in other conditions above, including condition number 2.
Okay, so I just want to be clear. So it's not that you will submit, it is respondent shall keep wind observation data, as well as, I didn't have the exact wording, but the working face, changes in the working face based on response to odor complaints or wind conditions, and make such data available upon request to the district. Attention, Larry Israel?
Yes, I believe that's correct.
Okay. All right. So if we're agreeing on that, if the parties are agreeing on that, if Mr. Jasinski, after the hearing, if you could submit that language to the clerk so that she can have it to include. That would be helpful. Okay. Okay, so that was one of the issues. Would you like to move on to the next?
I think the next one was the trigger for operation of the orchard fans. We would propose that that would operate similarly to changes in working face conditions. So it'd be triggered off of wind projections. So Chiquita would start operation of the fans at the very least 1 hour in advance of a wind projection that's between 1 and 5 miles an hour towards Valverde.
And would that also be triggered for odor complaints or just for wind conditions?
I believe the stipulation that we were discussing was that they will at least be triggered on wind conditions, which I think would maintain at least some flexibility that they could be operated separately even without wind conditions.
Did you, yeah, I think you cut out. Did you say at least? Are those the words you began with?
Yes.
Okay. And is that, did Mr. Dudzinski, your understanding?
Yes.
Stipulation. I should stop. Yes, thank you, Ms. Verdugo-Peralta, for any questions of the board as we go through.
I just want to know, have we closed public comment?
We did, because no other member of the public indicated they wish to be heard today.
Okay, I didn't hear that. Okay. I'm just concerned that we just didn't give them a good opportunity, that they had to wait all day and that we lost the majority of them. So I think that's very unfortunate.
To be clear, there were not that many more participants at the beginning of the, I can see all the attendees and participants and panelists. There were not that many additional. There may have been 1 or 2 more. And at the last hearing, at the time for public comment, that's why I kept apprising the public as to when we would hear this matter and that we would hear public comment at the end and then come back at the time we said with public comment, was because last time they came on as we were doing public comment. So I can again call for it. I see fewer people on, but if there's any member of the public who is on, I do see there are some who did speak last time. If they had any other comments, we are willing and happy to hear those comments. Just raise your hand virtually. Okay. I don't see anyone raising their hands, but I'll keep an eye out. Ms. Verdugo-Peralta.
Thank you.
Any other questions though on that proposed change? And Mr. Balagopalan, that was your request. Does that seem adequate to you? You are muted, but.
Yeah, yes, thank you. I'm satisfied with that.
Thank you. Okay, Mr. Dudzinski, the next issue.
I think it was to add the conditional use permit to the website in an easily accessible format. I think we stipulated with the district that we would add that to condition 16F.
And it would be Romanet 5, and it would be the facility's current conditional use permit?
That's correct.
Okay.
If I can add one aspect to that, I think we would also change, after adding Roman numeral 5 to 16F itself, which is on line 12 of that page, to change the title of that section to be reports, permits, and orders, just so that it's clearly labeled.
Mr. Dudzinski, you agree to that, correct? Okay. That's a good additional change. Okay, to be very clear, where the public can actually access the CUP. Okay, and I think there's one one more issue, and that is of the status and modification hearing, the next one.
Right, and so we had stipulated that being March 11th, the thinking there being that we wanted to have the report from the consultant that's being retained in enough time for us to prepare to present any of those findings to the board, and if any modifications to the order would need to be made. So the modification that we would propose making would be based on whether there would be any significant changes that would warrant board attention. And what we were thinking is that the trigger there would be, if Chiquita receives 2 NOVs in the intervening time period, we would come back to the board to discuss.
Okay, so leaving the March 11th date with the understanding that if 2 or more NOVs are received in that time frame. And
that's right.
And Ms. Roberts, that was also your
Yes.
thinking. Okay. So how would that look? That would look, shall return for a status hearing on March 11th.
I think it can be a separate condition, Madam Chair, that should 2 or more NOVs be issued following the date of this order and prior to March 11th, the parties will move to hold an earlier status hearing.
Say the last part, the parties will move.
Yes, for an earlier status hearing.
Madam Clerk, can you remind me if that were to happen, how long it would take to schedule a status hearing?
Order for abatements require published notice, a 10-day published notice, meaning once they give us the petition, it will take us anywhere between 15 and 21 days for them to be, we need it that far in advance for them to be heard.
Okay, so I would like to say we'll immediately move. As soon as that NOV is issued, we would need to move into action to notice another status hearing. And is that agreed on by both parties?
Yes.
Okay. Thank you. Board members, any questions on that or anything else? Because I believe that was all of the issues we asked the parties to address. Okay. Thank you so much for being so responsive both times. And again, thanks to those members of the public who were able to be heard by this board and by the parties, triggering many of these changes. Board members, would anyone like to begin our discussion of good cause? Because we did not really get to that, given the changes we all wanted to see in the proposed order. Ms. Verdugo-Peralta.
With all due respect to everything that Mr. Dajinski has put forward, as well as Ms. Roberts, I still feel like maybe me, haven't taken enough time to look at what was presented in that EIR, mull it over, discuss it possibly, and be able to vote on it. To me, this is such an important issue that's affecting so many people that I want to make sure that we've thought it through thoroughly.
I want to be clear again, maybe I just need to say it in a different way. We took official notice that that document exists and that LA County made those conclusions. We are not taking official notice of the veracity, meaning the truthfulness of those conclusions. To do that, we would have to do the study, or the studies would have to be presented. We would have to have witnesses. We would have to understand, which is not going to happen in this particular hearing. Also, I wanted to say that while I think the thinking of the parties was to present whatever there is that exists. That existed as of the beginning of 2017. We know that conditions based on the testimony and the evidence we received during these hearings have significantly changed in the surrounding communities in 2020, just in 2020 alone. I don't know if it changed to a lesser extent in 2019 and to a lesser extent in 2018, but certainly it has changed significantly in 2020. And so for all those reasons, we are not taking, our discussions today would not really include, we're just taking notice that that was done and there's some starting point that someone looked at. But that's not saying today that we are considering this order based on the fact that there are no significant cancer risks or there are no significant health risks or there is no, in fact, I looked quickly at the EIR, they just didn't have enough data to even make a decision one way or the other whether property values have been affected. So
that was my feeling also.
So just to be clear, that would not be the basis of our decision. Our decision today is simply to look at all of the evidence we have collected during the first day of hearings when really without all the evidence, plus the profferings today with regard to explanations of how the changes address the concerns that we expressed last time and determine whether there's good cause to issue this stipulated order, which means essentially, do we think that what has been proposed are both backed by the evidence that we have received and will make some difference in the community in the short term. And the reason why I say in the short term is because we will be back with more information. This is a starting point as it's been presented. And we will be back in March, the latest, mid-March, with the conclusions of the consultant and all of the things that the consultant will be looking at and best practices and all of those things that are part of this this order. So that should frame our discussion of good cause. And if no one wants to begin, I can say, I feel, oh, Dr. Bernstein, did you want to begin?
You mute.
I lost my cursor. Disappeared. I'll begin. I believe that we do have the elements necessary to impart good cause in this case. I want to congratulate both Ms. Roberts and Mr. Duginski for their efforts in responding to the many comments that were made in the last hearing and in this hearing, and the comments from my fellow board members to craft something that would be a beginning step to actually provide environmental justice, in quotes. It seems to me that this is something that we do in every case that we review. We're looking to impart fair and equitable delineation and enforcement of environmental laws, regulations, and policies, which is the nature of environmental justice. And we've taken testimony from many of the residents. We were alarmed and frustrated with some of the things that we heard. And I believe that Ms. Roberts, Mr. Jasinski have actually crafted a document with additional modifications so that there's a very clear path to compliance and improving the environmental situation for that neighborhood. And in my opinion, we've carefully deliberated and listened to the evidence that has been proposed, the documentation, the many documents that have sent to us, and peruse them so that we can in fact craft basically a path for better and for delineation of a better environment and for compliance for the Chiquita Canyon landfill. Thank you.
Thank you, Dr. Bernstein. I want to echo that I do feel that we can find good cause. I want to go back to the members of the community that are most affected, and just state for the record and for them that are those that are listening, that we don't, and I think you've heard from the parties, we don't think that tomorrow this order is going to go into effect and everything is going to be 100% better. Our hearts go out to the community. We have clearly heard your concerns, and so have the parties. And our hope, as Dr. Bernstein said, is that this order is merely a first step to gather information that is necessary. And I think it really goes towards doing that, and starts to implement important changes that will make it more acceptable in your community in the interim. And I want to say in particular that I very much appreciated that I heard from the evidence that I heard as I heard it in the last hearing. It seemed to me that as Mr. Israel presented it, and as I think the complaints bore out, it became much more insufferable in the community when the working phase was moved to cell 6. And so my request to the parties was, can we limit the working phase? Can we try to move it so that it's blocked by something? And can you find another place to temporarily move the trash that doesn't require permitting and a long lead time? And it sounds to me from what we heard today that that's exactly what Chiquita Canyon did. And they found extra space in the cells that they've already mostly filled, that they were using for other purposes, and they are going to dedicate as much as they can, and on those days in particular where those conditions are likely to cause odor concerns in the community, to take 50% of that and move it to the incoming trash and move it to that section, so that the working phase is much more narrow and confined, and thus reducing odors. I think that's going to make it's going to be very helpful. Plus the increased odor patrols and the increased requirements for the odor patrol to help to mitigate any odor fatigue. And also just, we heard a lot of concerns from the community members that they simply were not having their voices heard and they couldn't get any information, and to have so much more robust information available so accessibly on the website, including, as Ms. Roberts so well laid out during her presentation, the 1-800-CUT-SMOG number and all the other information, so that any complaints can be reported to both the landfill as well as to other authorities. And again, just to remind members of the public that this will be an enforceable order should we move and adopt it today, and that it is enforceable just like any other rule or regulation of the district. And we will have a comeback tentatively on March 11th. That's what we will be noticing. But if there are 2 NOVs or more between now and then, as quickly as possible, we will come back for another status and possible modification and try to address the problem. And of course, as has been mentioned by Dr. Bernstein, there is the best available practices and the other important items that the consultant will be looking into. So hopefully this can be addressed in the longer term. Mr. Balagopalan.
Yes, I echo all what you all have said. I also wanted to add, I think since the last time after the community spoke, I think there's been more comprehensive community outreach listed here, including starting January, they're going to hold a public 1-hour community meeting once a month. They're going to participate in the CAC community meetings and if it's on the agenda, they're going to be participating. So I think I think we heard from the community, there's not been that much outreach and they're not been heard. So I think some of these changes and is really very good, having the outreach once a month by Zoom, or if conditions are okay, maybe in-person meeting, but at least by Zoom, and they'll publish all that information. So I think that is the community should at least take heart that at least there's more communication will be held as part of this order. And I also I'm looking forward to seeing the report on the best practices, and I just wanted to say that I hope it's a comprehensive, not only it looks all aspects of the landfill, but the daily cover, the enhanced interim cover, the landfill gas collection, and and all aspects of it, and they identify what are the best practices established in other similar landfills that could be incorporated here, or why they can do it here because of whatever the situation is. So I'm looking forward to the consultant's report in March or sooner.
Thank you. Any other comments before we make a motion? Okay. Dr. Bernstein, did you want to make a motion since you wanted to begin I'm going to leave it to you if you'd like to. Otherwise, I'm happy to make a motion. And it would simply be a straightforward motion based on the good cause findings that we just made to grant the stipulated order for abatement in exhibit number 3 with the changes that were discussed.
Okay, so let me just organize my paperwork here. All right, I'll give it a try, Madam Chair. In the matter of Chiquita Canyon LLC, a Delaware corporation, case number 6177-1, I move that we find good cause to grant an order of abatement as set forth in proposed findings and decisions, which is exhibit. What exhibit is that? Sorry.
3.
3.
Okay, I was just making sure. Exhibit 3 with the following changes that have been mentioned already, or do I need a list?
Usually I would ask that you list it for the clerk, but since the ones that were not already clearly stated will be sent over by Mr. Dudzinski, you don't have to repeat them. Just include them.
Okay.
I'm going to second that motion, and just to clarify, for a stipulated order for abatement. Is that correct?
Yes, ma'am. Thank you.
Okay. And is there any other discussion on that motion? And that was well done, Dr. Bernstein.
I took the easy, the Cliff Note version.
That's all you need. Any discussion on that motion? Okay.
I just wanted to. This has been we've had some protracted hearing before, but this has been a protracted hearing, and it was moved every single one of the board members with regards to feeling that the community had been let down. That was a general impression that I got, that the community was basically being ignored. I feel very good about the fact that we're stepping up and making sure that their voices are heard and they are not being ignored. And we are putting a roadmap forward to make sure that better environment for that neighborhood. And I'm sure all my colleagues feel very well and very good about that as well.
Thank you for that, Dr. Bernstein. I'm going to call for a
well said.
Yes, very well said. Mr. Balagopalan, how do you vote on that motion?
Yes.
Ms. Verdugo Peralta, how do you vote on that motion?
No.
No. Mr. Ali, how do you vote?
No.
I vote yes. And Dr. Bernstein, you vote?
Yes, aye.
Okay. And the motion will pass 3-2. I'm going to give my fellow board members the opportunity, if you want, to explain your no vote, if you'd like to. No. Ms. Verdugo Peralta, would you like to?
I I don't think that we have gone far enough. I don't think that, I think there's a little bit more that we could have done. I'm disappointed that there weren't people from the public who were there to speak. It's a work day. Maybe this is a hearing that should have been held on a Saturday or an evening. I don't know whether that would have made that much difference or not, but I just don't feel that we are addressing completely to the extent that we can. And as Dr. Bernstein said, I recognize the fact that all of us don't feel good about this and that we all have mixed feelings about a lot of things, but I just can't vote for this in good conscience. And I would like to have seen a little bit more going forward, maybe in reference to the percentage of the working face being moved. Maybe that would have moved me a little bit more, but I don't think 50% is enough for what these people are going through.
Thank you for that. And for the record, that is always a helpful comment during the hearing, so that if that is the thought, that perhaps we could have requested of the parties, could they do more? Just so we know that if that's on your mind, that's really important that we voice it. The comment regarding, well, two things. First of all, after this hearing, we have now we have called for a March 11th hearing date, perhaps after or soon thereafter. So perhaps it would make sense either for the hearing board to work with public affairs after this hearing to see if we could accommodate an evening hearing on March 11th, or perhaps a Saturday hearing as soon thereafter, meaning that weekend that follows. I don't have the dates in front of me. So that's one thing I think that's important to do. And again, I don't, I think right now the hearing board and the district continue to scramble from COVID. And I think that perhaps it was the prevailing thought, I don't know, no one ever expressed this, that it's easier to access hearings because they're remote and nobody has to travel. And usually we like to go to the community. But that's not to say that that was not an oversight and should be for. So is that you, Mr. Van Koppel?
Yeah.
Somebody, that was you. Okay. The second issue with regard to other things where you think we should have gone farther, I think let's talk about other things so that the parties can be prepared if we come back for the status and we hear that conditions are not improved, that perhaps we can do more. And that is the point of the status conference. That's why I originally wanted to have it held earlier in February, because I want to understand whether these changes are in fact making a real impact in the short term. And that was my concern all along. But let's leave the parties with the idea that we are going to want to hear more about minimizing that cell 6 working phase, and also how far they've come in perhaps relocating it, because it was our understanding that that cell is the closest to the community without an obstruction in the way of the odors reaching the community. Is there anything else that you think should have been addressed?
I go along very much with the fact of what you were saying earlier, that the EIR, which was done in 2017, does not give us a picture of what's going on right now. And to me, it was fruitless in a way. I appreciate the effort by Mr. Dujinski, but that did not give me what I needed.
No.
It did not give me the information to be able to look at what the health effects truly are, because it sounds like they're much worse than what that EIR was able or not able to pick up.
And I appreciate that. And I just want to, again, just mention the limitations of the hearing board so that all the board members understand and the public understands as well. Even through a contested order for abatement, we could not require anything that is not otherwise required by the rules. The parties could come back and stipulate to do a health study. If that's something you think you're going to want to see, especially if the situation in that community has not changed by the March 11th hearing or soon thereafter, as we can have a hearing.
I just wanted to say that I don't think that the public understands what our limitations are. That's another factor because of the fact that they are assuming that as the AQMD, we have full authority to come back at whether it's this company or any other company. And when it is limited, and I feel like we were very limited with this case, I think that we need to explain that more to the public so that they understand that we're not letting, it's not a matter of the fox watching the chicken coop. That's not the case.
Thank
you. I do think, you know, and I thought I expressed myself earlier that I do really want to see a health study.
And
that's very important.
Then if we don't think that I have adequately explained to the community, let me try to do it again. This hearing board only has jurisdiction over, first of all, what is presented in a petition to us, and also only have jurisdiction over the rules and regulations of the district and the Health and Safety Code 41-700 and 47. I can't remember, 41-701, which is opacity, but 41-700, which is nuisance. And also, as Ms. Roberts showed earlier in the hearing, there's also a hearing board rule, 402, which also addresses essentially exactly the same as the Health and Safety Code, nuisance. So our jurisdiction ends at hearing, in this case, it's an order for abatement, stipulated, so we're not really hearing violations, but essentially, just to make it easier, of hearing violations that have to do with rules and regulations of the district or that health and safety, those health and safety codes. We are also limited, so we can't hear anything that's outside of those boundaries. And we have no ability to help or to adopt orders that address anything outside of those rules and regulations. In addition, we cannot in our orders generally require any respondent or facility to undertake anything that is above and beyond what would otherwise be required by regulations. So we can have conditions that stand in, okay, you're not in compliance with a particular rule or regulation, let's get you there. And these conditions are imposed so that there's an alternative or there's a path to compliance, etc. Health studies are not something that we can normally require. The parties can stipulate to that as part of a stipulated order for abatement. And so if this continues to be an issue, and continues to be an issue because there's continuing odor complaints, continuing notices of violation, by the time we hear this case again, I'd like to then revisit whether the parties would stipulate that the respondent would undertake a health study. But it is not something that we could require. So if the parties do not agree, if the respondent does not agree, we do not have the jurisdiction, even if we converted this to a contested order for abatement, found a nuisance violation, we still could not require a health study without the stipulation of the parties. I hope that's clearer. We are very limited in our jurisdiction in that way. But I do want to make sure that we put out there for the parties any other issues that I think that's enough. You don't have to have any more issues. But Ms. Verdugo Peralta has now vocalized 3 issues. One is making sure that we try to have the next hearing at a time or on a day when more members of the public can be present, which we will work on for the status on March 11th or that Saturday. Also, we need to work, she would like the parties to address minimizing the working face even more. And we will take that up, especially if there are continuing complaints, and also revisiting the health study, especially if there are continuing complaints and NOVs. And I just wanted to reiterate why it is I am very much in favor of, I mean, we already took the vote, but just to address that, it's my feeling that we can't do everything at once. And I do feel that if we do not adopt an order like this, which has consultant studies and come back with best practices, et cetera, we're not going to get to, we're not going to start to address the problem. So I thought it was a good starting point. But just to let the public know as well, in similar cases, when we do have a comeback and there are continuing issues, the board historically has worked to address those issues much more vigorously, especially once we have additional information on other practices. And with that, is there anything else anyone else would like to say? Thank you. And then, so just to reiterate, it did pass 3-2. And I want to thank all members of the public for participating and also just being present. I want to thank the parties for addressing all the concerns that were expressed last time and during this hearing, and to continue to do that with the issues that were expressed. Thank you, Ms. Roberts, in particular, for making it so clear what the changes were with your PowerPoint presentation. And thank you, board members, for a very excellent discussion and for really addressing, I think, all of the major issues throughout this 2-day hearing, and for your continuing participation. And just a reminder, please, that all those papers for tomorrow's hearings are in your inbox, and that we are prepared for tomorrow's hearings. And if there's no other business, we are adjourned for the day. Thank you.
Okay, have a good evening, everybody.
Good evening, everyone. See you tomorrow.